Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. Oh my goodness. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And I do sincerely, dearly apologize. I got everything ready. Here's the story. Here's the story. You can tell me if you believe it or not. Am I just late, gay, and muted? Maybe. But here's the story we're going to go with. Story is I got the stream ready. I set everything up, kind of. And I went up to take a shower, which I don't know. What is happening with this hair? I went up to take a shower, and then I came back downstairs, and my cameras weren't turning on. My mouse wasn't moving. Nothing was happening. It was an abject disaster. And what is this? What? I'm in the middle of a show, sweetie. You gotta go to bed. Stop doing this. Stop doing this, sweetie. You gotta go back to bed. Okay. Okay, guys, I'll be right back. I'll be right back. Oh my goodness, you cannot find TV like this anywhere else but YouTube. I would have been fired so many times. Look, here's the thing. If I keep having to leave like this in the middle of the show, I'm gonna have to like pay the chair. What is this? Ridiculous. Okay, I do apologize, but I had a emergency. I mean, some kids. Very important. Of an I can't go to bed emergency. Anyway. Okay. So today we're talking about Meyer versus Waid. Meyer versus Waid. I'm grabbing the documents right now. I would have grabbed them before, but everything decided to break. Let's see. Here we go. These are fresh off the press today. All 116 pages of documents here. We're gonna see what we've got. Hold on. Come on. 116 pages? These people are boring. Meyer versus Waid. Meyer versus... There we go. There we go. Everything about this is slow, and I apologize. Okay, so other things going on. let me give you guys some previews while I get this thing set up. And again, I apologize. My computer decided to quit everything. Just decided to quit life. But, and I have a mild cold. So here's the deal. Here's what we have coming over the next week. Many of you know by now that, of course, Mars Girl, the thirstiest of attention thoughts, who cannot manage at all to get, I guess, an audience or attention or people to listen to her. Can't do it. Just cannot do it, right? She has come out and decided that since no one was paying enough attention to her, that she would attack Vic's mom, right? That was a solid plan that she had. That she would go after Vic's mom. She would lie openly about Vic and his upbringing and imply that somehow Vic, coming from a single mother, had just a ton of money sitting around, right? But here's the thing. I figured this out. You guys might be confused about Mars Girl. I am not. I have figured out why she thinks Vic has so much money. And it's all a matter of perspective. It's all a matter of perspective. You see, when you have to mortgage 8 of your cat's 9 lives to buy your next little figurine to put on your shelf to feed your infantilism and your escape from your failure of a life, well, then anybody who's ever saved maybe 15, 20 bucks up in a savings account looks like Bill Gates to you. You poor, disgusting thing. Absolutely vile. Absolutely vile. So, there is a preview of a show coming at some point. At some point, Mars Girl will get a show. And it will be a show. All right? It will be a show. And we will be combining, I'll just tell you. We're going to talk about your legal mishaps, your professional failure, your economic failure, and your feline failure. And we're also going to talk just about you in general, you failure. So I heard today, Mars Girl was on Channel Awesome for 9 years and couldn't muster 10,000 subscribers. That's the level of importance. Are we looking for a motive for Mars Girl at this point? Are we still wondering why Mars Girl is involved in this situation? What she was hoping to accomplish by being the leader, right, of the movement to start removing problematic voice actors from the industry. Man, that might have gotten her all the way up to what, 18,050 subscribers or something. What is this? What is with these people? Very professional, I know. I'm sorry. Oh, speaking of which, are the consummate unprofessional shirts up yet? Let me check. I don't know if they are. Not yet. Not yet. What is this? We are putting up shirts for the consummate unprofessional. Okay? That should be out very soon. I thought we'd have them out today, but it's been busy. Okay. Next. Oh yeah, and we're definitely going to talk about Dead Juwario. We're definitely going to talk about that disgusting pile of garbage, dead in the ground corpse Juwario. Minecrafted himself. We're going to talk about that guy. I forgot about that. We're going to dig up that corpse and piss on it just a little bit. Okay. That's going to happen in the Mars Girl episode. Oh, hopefully before that, in the next day or two, I am hoping, very tentative, some of you may know, some of you may not know, the NFL draft is coming up this weekend. Does that mean anything to me? No. Does that mean anything to you? Maybe. But who it means a lot to is Amazon Emeritus of Beard, Harris, Bullock, and Hughes, Miss Christina, who is an NFL registered agent. And I am hoping to have Miss Christina on the show to talk about, one, working at Beard, Harris, Bullock, and Hughes, being the Amazon Emeritus, which means she was the first attorney hired by Beard and Harris, I believe. So she's been working there for quite some time. We're going to get to know her a little bit, her background, and what she does. I thought it might be really interesting for you guys to learn about, and me to learn about what agency representation in the NFL is like, and talk about maybe how that translates to stuff like Major League Gaming and other agency representations. So that should be a very interesting interview. It'll only be tangentially related to Vic, but I've been wanting to meet Christina for a long time. I know many of you have, and this is a perfect time because she is an NFL agent, and we've got the draft coming up. So she's actually been representing young players looking to get into the NFL. So there you go. That's coming up this week as well. And then who knows what else, because every day is a surprise. Every day is a surprise. So that'll be fun. All right, let me get the super chats, the $20 plus super chats out of the way. We'll address them, and then we will go straight into Meyer versus Waid. And I'm going to apologize in advance if I have to, like, cough a little bit, or if my throat catches. Like I said, I am dealing with a mild cold, so bear with me, guys. I apologize. Blink Your Eyes 1400 says, I'm excited to finally be able to add to the GoFundMe, and never thought I would have a friend who would also donate and share with one of his friends. I also have another praying for him. Did you hear about them targeting his mom? Why, yes, I did. Why, yes, I did. And them is a bit rude. I mean, Kaylin Saucedo is fat, but I don't know if she is two people fat. But we'll talk about that. The Spawning Pit says, you don't have to read these if you don't want to. I just wanted to ask if you were doing okay. Saw that Soye said you're next. Regardless of the boye behind the words, it comes off as intimidating to me considering Vic. You know what? I am just fine. I am not intimidated by Ronald Toye or Monica Rial or any of these people. Here's the deal. I haven't done anything actionable to them. I can back up what I say with proof, and I can back it up with proof that they know exists. They just don't know I have it. So it'll be really embarrassing for them if they do try something like that. Plus, they have much bigger fish to fry than little old me up here in Minnesota. Why would you burn your bank account on that? I do know, like, I don't know if they realize, but I might know a lawyer or two who'd be willing, and more than willing, happy to help out with my upcoming case if I have a case from them. And they'll get to know my lawyer very, very well if that happens. But we'll see. We'll see. Here's the problem, Toye. Prove damages. You're still employed? You probably shouldn't be. If I was your boss, I'd fire you. I've never contacted your employer. I've never done anything to damage your ability to be hired. So good luck with that one. if you're gonna go ahead and come after me because of things I've said about Monica, she's still employed, still getting invited to conventions, except the ones that she decides to breach her own contract to, and then later, you know, come up with some ridiculously stupid settlement with the con owner to allow her to be in abject violation of the plain language of her contract. But that's okay. You can do that. And she did. For the entire world to see, she pretended to be scared and hired the mall ninja. Guys, that's one thing we have to do. At some point, I'm not sure if this is going to be a video or in a live stream, but we're going to talk about Monica Rial's very qualified private security that they hired to guard the comic shop in northern in Frisco or whatever, in Frisco, Texas. The very competent, you know, Kamehacon is full of off-duty PD. They've got professional security there, and who these guys hired is the mall ninja, rocking that camo jacket and a stern look. And a stern look that could dry up, that could I can't even finish that joke. oh my gosh. Ooh, a stern look that could dry up a nympho on Tuesday. All right. That guy, we're gonna have to talk about him. I cannot take credit for any of this. Other people have dug up the information on that guy. But the fact that their idea of competent security is, you know, is telling. It's telling of their overall competence and their overall grasp of the situation. Whew. These people, man. These people. No, I'm not concerned about them. But thank you. I do appreciate your concern for my well-being. Very, very much. I don't mean to downplay that, but no, I'm not worried because I'm very confident in what I'm doing and my methodology and my vetting of facts and informants. Okay, the Spawning Pit says, so take my money and know that there are people like myself who watch and sincerely appreciate the values you seem to uphold by your actions. There was a point where I thought only I valued truth over perception. Thank you. You're not alone, man. You're not alone. Innocuous Remark says, you're very entertaining, but you're also helping many people like me learn how the law really works. I appreciate that. Thank you. That's my goal, man. Fafulin says, the Vic drama reminds me of Congress and the Mueller report. We have the Kick Vickers keep saying, wait until the investigation comes out and you'll see all is evil, but all his evil. But when it finally does, it's a whole lot of nothing. Oh, that... Did you guys see Toye? Did you guys see Toye's brilliant tweet where he says, actually, I had no idea what's in the investigation. Oh, thanks, Ron. Now you have just another piece of evidence pointing to actual malice. Let me explain this for the audience. You know how they keep saying defamation cases are really hard to win, especially for a public figure? That's for something called the public figure doctrine, which came out New York Times versus Sullivan. I believe it was 1972 or 7 or something. Doesn't matter. Doesn't matter. New York Times versus Sullivan. All right? Public figure doctrine states that if someone is a public figure, which used to really only mean government official and then the most famous person you could possibly imagine, a literal, like a paparazzi magnet, a Michael Jackson, right? Someone who, if you were walking down the street, everybody who saw them would know who they were. That was a public figure. That was a public big figure. Nowadays, they're trying to say everybody on Twitter with more than 500 followers is a public figure, but that's a different thing. Let's just accept it as true. A public figure has to prove actual malice to prevail in defamation claim. That means that they have to prove knowledge of the falsity or a reckless disregard for the truth. Okay? Knowledge of the falsity or reckless disregard for the truth. Hello, enter Ron Toye, who spends 2 to 3 months talking about an investigation over and over and over, potentially, allegedly being in contact with cons and other people about this investigation, encouraging them to kick Vic, right? Now, heat gets turned up on Ron. He gets sued. He freaks out because the little boy is scared out of his mind, and you can tell it's written all over every tweet with every emoji. The man is terrified. So what's he do? Maybe on advice of counsel, maybe on his own, he comes out with his tweet that says, actually, I don't know what's in the investigation. Well, Ron, here's the problem. That either means that you know that what you're insinuating and implying about the investigation is a falsity because you don't know what's in it. So even if you call it he's being investigated for sexual harassment or assault, you don't know what's in it. You just said that. You just knew that there was an investigation. Maybe they were looking for his cat. How do you know? Maybe Mars Girl ate it. How do you know? You don't know what's in it. All right. So then, even if that's not knowledge of the falsity, which I'd contend it definitely is, it is certainly a reckless disregard for the truth to leak information that you don't have about an investigation to imply that someone is a sexual predator. That is 100% reckless disregard for the truth. There's no way around you saying that. That was a terrible tweet. You did it. All right. BN Josh says, hey, Nick, just got Ilium and Olympus today. Attaboy. Cracked it open to take a quick peek, and this is the first line I saw. So these are the boobs that launched 1,000 ships. Was not expecting that. Man, that book is a non-stop ride. Non-stop. It's great. Read it twice. That's what I did. Actually, I've read it 3 or 4 times. DCV Titan says, I've got a question about your tweets about employment investigations in Texas. Don't we know from Big Brain Reality Check that there were Sony investigations? Would that change things on that front? No, because Vic's employment contract is in Texas. So if they're conducting investigations into Funimation, his contracts with Funimation, that's in Texas. Contracts enforced in Texas. It's in Texas. Ink Penification. Who is dumber? Mark, racism is broad Waid, or Ron, I drank some soy juice and spend most of my nights in the doghouse soye. At this point, I think Toye is freeing Tibet faster than Waid. So, we'll see. We'll see who's a burnt out husk first. Coop says, Nick, you late? Don't be a Rama. Don't be Rama. Do you understand? You don't sniff petrol from a can. You put your petrol in the car. It goes, don't be Rama, and sniff it up your nose. There you go. Thank you. Bo Stoker says, super late, ultra gay. Any word on that case? Either passing it along to the eyes that would be beneficial, or your gay blue eyes. Stop eye rape. Just don't make me go to my alt account and mock your childlike beard. Oh, rude. Rude. No, I've passed on the case. I don't know who's going to look into it and signal boost it or whatnot, but, you know, we'll have to see. We'll have to see. Swarm069 says, my God, Nick, go scorched earth on this thought. I can only get so hard. Well, no promises, but yeah. Yeah. Comic Crow Chronicles says, Nick, can you please let us know what you think of BPM's awesome Jelly Bean dubstep tribute? Oh, I haven't seen it. You're the star, and it's epic. I'll open it. I'll have to watch it later. Maybe we'll watch it on stream or something. Chan says, did you see Ron Soye's tweet threatening to come after you? We will deal with Nick, he or she claims. Well, again, they have much more important things to deal with than little old me. And that's paying for their lawsuit. Rolana 1 says, any chance of a stream with Yellow Flash, Tug, and or Supergirl? I think Flash. I keep saying I'm sorry. How unprofessional of me. I think Flash is going to be on my show about Mars Girl. I don't know if anybody else. I'm trying to work in a very special guest or two for that Mars Girl show, but Flash will be on there, I believe. We'll see about Tug and or Supergirl. Not sure yet. Dorby says Soye is going to deal with you on his therapist couch. That could be true. Cars in Depth says happy Passover from the Judean People's Front. Back at you, brother. Back at you, brother. I doubt there's an ethics violation on Zaid. He's just a scumbag. But he's like, people think that these ethics rules against lawyers are very, very strict and are like ruthlessly implied. And we have some like very like it's really easy to break them. It's not. It's difficult to break the rules against lawyers. Professional conduct, unless you bang your clients. That's a no-no. Like you've passed half of the professional responsibility exam if you just know don't have sex with your clients. Just don't do it. Don't bang your clients. If you steal money from your clients, that's bad. That's bad. If you lie or perjure yourself, that's bad. And by lie, I mean fraud. I mean a lie that matters. Fraud, fraudulent misrepresentation, lying under oath, perjury. You know, those are criminal lies. Not just like, well, I had a sandwich today, but you actually had soup. No one cares. Look, saying that Renfamous is the fattest orca on the planet is not actionable, ever. It's not conduct unbecoming of an attorney, unless maybe, and only maybe, if I was representing her or representing someone against her. And only maybe then could we escape that gravity well and get that comment into the eyes of the disciplinary board. As long as I'm not lying about Ren, and since her belt line is equator, you know, it's hard to do so. It's hard to do so. But yeah. All right. Mithrin Emrys says Gertz versus Welsh has a lot to answer for with the establishment of the limited and involuntary public figure doctrines. Justice Thomas was right. SCOTUS needs to revisit that whole line of cases. Absolutely. Absolutely. And you know a lot about that. But yes, that needs to be walked back. Corathus says, as someone who has been a victim of false reporting multiple times, I sincerely thank you, Ty, and all involved in the defense for all you do. I can tell you the effects of such an event are long-lasting. I wish them on no one. Yeah, man. I'm sorry to hear that you went through that. I really am. But we'll see. People are learning that they have to fight back. If that's one thing we're learning from all this, it's that fighting back is effective. Right? Fighting back works. Everybody has been told to lay down and die. You know, it'll blow over. Apologize. Say you're sorry. You know, mitigate your words a little bit. I'm sorry for this or that. You know, I didn't mean to offend anybody. Please let me back in. It doesn't work. It only works if they were going to let you back in anyway. And listen, the people who get away with an apology, for example, Renfamous. Renfamous, horrible comments about gays, horrible comments about all gay marriage in general, all sorts of people from decades ago. She suggested that someone should have drowned their child. You know, very, very awful things from about a decade ago. Maybe a little bit less. But Renfamous was able to, you know, overcome it. Jessie Thoughtmore, right? She darkened her skin to do a costume. She culturally appropriated some race and did a cosplay of it. And, you know, for many people, that's unforgivable. But Thoughtmore's allowed back in. Why? Why are these people allowed back in? Because they were always going to be allowed in. They always were. They could have actually raped someone like Juwario, for example. And the Kaylin Saucedos of the world would have apologized for it. So they would have forgiven them. No, it's fine. It's fine. You went ahead and raped them. But this guy, did you see this guy ate a jelly bean? Let's remember that. All right. Cowboy FMJ91 says, since we know people like Mars Girl and Anime News Network would be more costly to sue, could Vic wait until he gets reimbursed by Funimation, has a larger war chest, or would that be too late? I mean, it all depends on how things goes. Things go. Lots of different possibilities there. Funimation could be a short thing. They could roll over and settle very quickly. It could be a long thing. We don't know. There could be money involved. There could be lots of money, little money. Hard to say. I think we're doing a just fine job on the GoFundMe that will hopefully allow, you know, a Mars Girl to be brought into the case as soon as it's prudent. Okay? So, Mars Girl, we're at $142,000, by the way. So thank you for that. Mars Girl, of course, is a little bit just more complicated target for the jurisdictional issue. Doesn't mean she's necessarily super expensive to sue. It's just the first round could be consolidated and done in Texas. Notice all of them are Texas defendants. Vic is submitting to Texas as a forum, and there is no jurisdictional issue, and it's one clean shot. Mars Girl, they would have to try and bring to Texas and argue that Texas has jurisdiction over her to bring her in that first round. Otherwise, they have to sue her separately. And if they're doing that, why don't they get some things started? They can do a suit against Mars Girl at any time, as soon as they have, you know, what kind of information they need. But I'll tell you, if you want to get sued, one way to probably do it is to go ahead and keep attacking someone's mom who already could sue you. I guess that seems like a stupid plan to me, especially for someone who didn't start it, right? You didn't start it back in January when you started it. 117 Haseo says, I sent you some choice screenshots from your stream on the 19th that I think would make great merchandise, like a new mug look for Chakra Motive. And when is your tweet replies? Okay, I'll have to look for him. Buddy. Xenobit says, fundraisers, lawsuits, super chats, big money, big prizes. I love it. All right, guys. Let's jump into these documents. I'm going to change out the layout here. Oh wait, nope. We've got a justice chat for $20. Shadow Scar Knight. As someone who's already contributed $250 to Vic's GoFundMe, whoa, thank you. That's amazing. I'll certainly give the man some more with money I've made through commissions. Vic is a wholesome, lovable dude, and you are entertaining AF. Keep up the good work and fight the good fight. It is my pleasure. My pleasure. And thank you so much for being very generous to Vic. You know, there's without this sounds so cheesy and campy, but honestly, without you guys supporting him, without the support from the fans, he'd be dead in the water. He might be dead in the ground. Like that's a very real possibility. That's what's so awful about this is that I think that people knew that that was a real possibility, that he'd be in the ground. They didn't expect him to have the fan support. He didn't expect the fan support, I don't believe. I don't think anybody did. I didn't even expect this level of fan support. You guys have been amazing to him and a literal lifeline, I believe. That's coming from me. I think that together you guys have actually kept a man's life and might actually be enough to keep the man's career. So we'll see. We'll see. Siren Jag says, I wrote a poem for tonight. I was recently told that a haiku has to be 575 and about nature. So here goes. Live stream boner crap. Mars Girl ate my cherry trees. Penis is now dead. Very nice. Very nice. All right, and this last one from Yellow Flash before we hit these things says, get in on the new hashtag monetize Ren trend, Nick. You'd make a killing. Here's $5 to give you the idea, and it will drive her crazy. Eat trash, Renfamous. No, don't do that. Don't do that. We need that trash to make energy. We need that trash to make energy. Okay. All right. Friends, let's get into some documents. What am I doing? I'm going to get one of these stream things. I don't know if you guys have seen these. They have buttons and it does all the stuff that I'm doing with like unadeptly with a mouse. It just does it for you. I really want one. Stream Deck. That's what they're called. I'm going to get one of those guys so that hopefully I can be less bad at this. No promises, warranties, or other guarantees. All right. So here we go. This is probably going to take up the rest of the show. We'll take some breaks between some of the documents, and we'll read through some super chats and stuff like that from the backlog. But this is Waid's response to Meyer's response to Waid's motion to dismiss on jurisdictional grounds. Aiko-chan, I would not be offended if you put me in your book. I'm pretty hard to offend. Pretty hard to offend. GR People says, you should always expect the fan support. That's how a comic like Vestige on Indiegogo is driving the comic industry pros mad. Yeah, by the way, hashtag war campaign. Thank you for creating a comic. And what are you guys, did you just annihilate Deadbeats? Are you guys ahead of Deadbeats already? Oh my gosh. Oh my goodness. Okay. So last thing here. Deadbeats. Deadbeats finally broke its goal, and a genuine congratulation to the 40 or so creators making an anthology called Deadbeats. They've broken their goal. They're now at $26,286 after 14 days. Vestige. Vestige is the graphic novel put out by War Campaign. The War Campaign, and they are at $30,540 after 2 days. 2 days. Remember this. 40 people, including several higher profile comic professionals involved in making an anthology book, including the ever influential super fatfamous did you guys see the fat guy defending Renfamous today? Thirsty out of his mind. Oh my gosh. But anyway, Vestige is put out by War Campaign, and it blows Deadbeats out of the water in a matter of hours, I think. In a matter of something less than a day, it passed it. How embarrassing. How embarrassing that this group of just internet trolls and nobodies who are certainly not industry professionals could put together some slapdash book. And I don't mean to degrade it, guys. I'm talking from their perspective, and just blow funding out of the water. So if you're looking at it, go check out Vestige. This is I can't show it on the stream. I don't think I can't show all of the art. It does have some adult art in it. You know, not like tasteless, very tasteful adult art. The art looks good. You know, but I'm not a good judge of it. But check it out. Check it out if you like it, guys. Or if you're interested. You know what I mean. You know what I mean. Don't put words in my mouth. All right. That aside, let's do this. Let's do this. John Wilson says, here's my chat cherry. Oh, thanks, buddy. Streamlabs has a phone app that does the same as the stream button thing. Also, thank you for all that you do. I actually care more about the law. Hashtag I stand with Vic. Thank you. Thank you so much. I'm glad. I really am glad. I did set out on this channel to make an educational channel about the law, and also to make it fun. I think we're doing it. All right, your boy Zach. This is defendant Mark Waid. Mark Waid files this reply to plaintiff's response to the motion to dismiss for lack of personal jurisdiction. The response. Jurisdictional discovery has only confirmed the court lacks personal jurisdiction over Waid. I'm going to tell you right now, good luck. Among other things, Plaintiff, who publicly advertised he was in New York. Nope, that's not a First of all, doesn't matter. Second of all, it doesn't matter. Did you guys listen to Wyclef back in the late 90s? Wyclef and The Rock? It doesn't matter. Neither shows nor even pleads Waid knew that plaintiff resided in Texas. Here's the interesting thing. Waid doesn't need to know he resides in Texas. That's a red herring argument right there. That's a red herring argument. Waid doesn't need to know that he lives in Texas. Waid needs to intentionally direct activity to a forum. It doesn't mean they have to knowingly direct it into a known forum. It just means they have to intentionally direct the activity into the forum, which, if you're calling someone in Texas to talk about a Texas contract between two Texas parties, you are intentionally directing activity into the forum of Texas, period. There's no way around it. Because if there was, you could just shoot that way and not know you were killing someone in South Dakota. So then they couldn't bring a wrongful death action because you're in a different state and you didn't know your bullet would go across the state line because you didn't know which way South Dakota was? Are we serious? Like, let's say you're standing near the border, you don't know, you point your gun at someone and shoot them and they die. So whatever criminal charges, that doesn't matter. Wrongful death action. What, South Dakota can't sue you because you didn't know he was over the border, or you can't be sued in South Dakota because you didn't know he was across the border? I'm sorry. Goodness. You directed your activity into South Dakota. Period. That's it. That's all you had to do. Oh my gosh. Additionally, thus conclusively defeating jurisdiction as to both claims. No. They know this, guys. They know this. They're burning time and burning Meyer's money. That's what they're doing. That's the whole goal here. Additionally, even this limited discovery revealed the substantive emptiness of plaintiff's accusations. Court lacks personal jurisdiction over Waid. If plaintiff persists in pursuing this meritless lawsuit, it cannot be in Texas. Plaintiff told the court jurisdictional discovery is necessary to defend against a motion to dismiss for lack of personal jurisdiction. That discovery only further showed the absence of jurisdiction as to each of plaintiff's claims, except that Waid was literally in Texas during the defamatory claim, or defamation claim. He's literally there. You cannot argue against it. He published statements to third parties while in Texas, to third parties in Texas about Meyer, and then admitted to it like a dumb fatso. What are we even doing here? Plaintiff failed to establish personal jurisdiction on tortious interference. Let's see. Plaintiff does not dispute that Waid had no knowledge that plaintiff lived in Texas. That doesn't matter. In fact, plaintiff does not dispute that plaintiff himself publicly identified his location as New York. It doesn't matter. Because his location wasn't in New York. It was in Texas. And so was Antarctic Press. And that is maybe the most telling issue here. His activity wasn't directed at Meyer. It was... This is the problem with this argument. Let me just put it down right now. He's not... The tortious interference, the person who has the effect of having their contract breached or interfered with or damaged in some way is the person withstanding to file suit. Okay? They are the person withstanding to file suit. Standing is your right to bring a claim. What they are not is the target of the activity. The target of the activity is the contractual relationship between them and the other party. That's the target. So, what matters is where the contract the locus of the contract, the nexus of the transaction, where that is. This is clearly in Texas. And despite all of his protestations, I'm too stupid to know what area code I just dialed. It doesn't matter because it's in Texas. You're targeting a contract in Texas. You're calling a Texas phone number. You're reaching into the forum to interfere with something in the forum. Intentionally, obviously. So you're done. All right. Tellingly, plaintiff does not even discuss the issue. That's because it's a non-issue. As Fifth Circuit has held, knowledge of the particular forum in which a potential plaintiff will bear the brunt of the harm forms an essential part of the Calder specific jurisdiction test. Revel versus Lidov. Fielding versus Hubert. The plaintiff must show that the defendant knew that the plaintiff would suffer the brunt of the harm caused by the tortious conduct in the forum. Well, of course. Of course he knows what he just... They're mincing words here. He knows that he will suffer the brunt of the harm in the forum. In the forum where it takes place. He's not going to suffer the harm in Alaska. He's not going to suffer the harm in New York. He's not going to suffer the harm in Charlottesville. He's not going to suffer the harm in Minnesota. He's going to suffer the harm in Texas, in the forum where it is, in the forum he's reaching into. Just because he doesn't know that it's Texas doesn't mean he's not going to suffer the harm in the forum. Plaintiff must show the defendant is alleged to have engaged in wrongful conduct targeted at a plaintiff whom the defendant knows to be a resident of the forum state. This is a completely, this is a very, very bad citation here. This is going to be a very, very unproblematic citation. The requirement is necessitated by the basic requirement, that a defendant purposefully availed himself of the benefits and protections of the forum. You do that when you enter the forum or reach into the forum. Wade's ignorance that the plaintiff was in Texas, a fact plaintiff himself has hid as indicated by his Twitter profile. I can't. So now, your Twitter profile location, that's the definitive and conclusive proof of where you are. That's how brain dead Mark Zaid is. But did Mark Zaid even write this response? Or was it Ryan Pierce? I don't know. I guess we'll find out at the end. If Zaid wrote this, this is embarrassingly bad. If Ryan Pierce wrote this, buddy, this is embarrassingly bad, but I'm going to give you credit. You're a junior attorney, and your boss brings you this trash heap of a case. You got to work it. You're not out boasting on social media about how great and wonderful you are. Zaid is. Zaid doesn't get a pass on this. Zaid's involved in this, and that's bad enough. You, Mr. Pierce, I hold no ill will or malice towards you. I know you're trying, and you got to do what you got to do. But we've been there, buddy. We've all been there. Wade's ignorance that plaintiff was in Texas defeats any finding of jurisdiction as a matter of law. No, imagine how broken the system is if you think that, well, I just didn't know where he was. Let's say someone has a GPS on their car, okay? Let's do a little thought exercise. They got a GPS on their car, and you buy from Russia, you'll buy, it's okay, we'll take American dollar for a little while, and we will sell you missile. Missile will go, it will lock onto friend's GPS, and it will bomb his car, no problem, guaranteed, all Soviet quality, right? You buy a missile that will track down the GPS of someone and blow up their car. And you just press the button and you have no idea where it goes. Well, you didn't know where they were. They can't sue you for blowing up their car. Too bad. Too bad. They're going to have to, I guess they're going to have to come to your state and sue you there. That's the idea. That's what they're going for here. C. Felding, knowledge that sufficient harm would be suffered in Texas is conspicuously lacking. That's not a good quote for you. Dismissing for lack of jurisdiction where defendant's affidavit, uncontroverted by the record, states that he did not even know that plaintiff was a resident of Texas. I think I've dug into Revell before. I don't remember the case, but I remember it being bad when they cited it before. Let's see. Fester versus Wolf says, finding no personal jurisdiction over fraud claims, even though defendant allegedly made fraudulent statements to Texas residents, where defendant did not know at the time that the alleged fraud the plaintiff lived in Texas. But did he make it to them while they were in Texas? Mithran Emmer says, this sounds like a seminar paper where the person researched the wrong cases, misunderstands the issues and tests, and is just splashing words around, hoping the professor takes pity on them and will give them a passing grade. Yeah, this is not, I mean, this is indicative of where their case is. That's the problem with it, or with their case, is that this is showing just how weak their case is. Plaintiff's case law is easily distinguished. That case law involves defendants who knew the plaintiffs resided in the forum state, and most of that case law also involved allegedly tortious communications with the plaintiffs themselves. In Twa versus Appletree. Yeah, nope. No, that primary case on which plaintiff relies. The plaintiff expressly claimed that the defendant knew the plaintiff lived in Texas during allegedly tortious phone calls with the plaintiff. I'm not going to read this footnote. When, as here, the defendant undisputedly lacked knowledge that the plaintiff was in Texas. No, here's the thing. No one believes that the plaintiff lacked knowledge that the defendant was in Texas. Plus, he reached into Texas. You're arguing that he dialed a Texas phone number and wasn't contacting Texas on purpose. Jurisdiction does not exist in plaintiff's case law is inapposite. In Twa, let's talk about this real quick. In Twa versus Appletree, if I remember correctly, it was even worse because the other party called him. The forum state reached out to him, but then he had significant conversation with them while they were in the forum state. In this case, what's his face? Waid reached into Texas. Oh my gosh, this is dumb. But this is just burning money, right? It's just burning money. Steve Fester, distinguishing Fifth Circuit case law involving allegedly tortious phone calls in which there was no dispute regarding whether the defendants knew the plaintiffs were in Texas. Okay? And finding no jurisdiction where, in contrast, plaintiffs failed to establish a prima facie case that defendant knew the plaintiffs resided in Texas. The prima facie case is the fact that he freaking called Texas at the time of the alleged tortious conduct. In fact, plaintiff's claims do not rise out of any communications at all between Waid and plaintiff himself. Plaintiff's other points only further show the absence of jurisdiction. Plaintiff relies entirely on the phone communications between Waid and Antarctic Press to suggest that Waid knew AP was in Texas at the time. But AP's location is immaterial given Waid's lack of knowledge regarding plaintiff's location. Oh, that's not true. Even putting that aside, there is no evidence Waid knew AP was in Texas at the time of the phone calls, despite calling and messaging. Never mind. I can only repeat myself so much. The only discovery on this point undercuts plaintiff's assertions. Plaintiff relies on Waid's recollection he met Ben or Joe Dunn previously, but there is no evidence any such meeting revealed AP to reside in Texas, and neither recalls meeting Waid, showing as Waid indicated any interactions were at industry functions and limited. Joe Dunn also testified that AP is not known as a Texas publisher in the industry. And here, cute. Do you convey that you're a Texas-based publisher in the course of AP's promotions? Typically not. Doesn't matter. Doesn't matter at all. You called a Texas phone number. Do you have a sign up at conventions that identifies you as based in San Antonio? No. Do you believe folks know where you're based on your what you see happen at these conventions and what you know about your reputation? I believe no. Left with no evidence, plaintiff resorts to conclusory assertions. Well, here's the problem, Pumpkin. You're talking about establishing a prima facie case for jurisdiction. And his assertions are actually a prima facie case for jurisdiction, but you know that. Response at 11, asserting Waid is simply not credible. Plaintiff's bald invective, however, is not evidence. No, the only bald invective here is Waid. In sum, plaintiff's inability to show Waid knew plaintiff resided in Texas by itself requires dismissal of his tortious interference claim, whether or not Waid knew about AP's location. Beyond that, however, plaintiff has no evidence Waid knew AP's location at the time of calls, other than the area code. Furthermore, even if Waid knew either plaintiff or AP were in Texas at the time of the calls, which he did not, the larger context, the publication of a book that has nothing to do with Texas, except that it's literally contracted in Texas to a publisher. I can't. Guys, my brain's gonna pop. My brain is gonna pop reading this. It doesn't matter if the book is about Texas. This is the weirdest argument that they've got. They keep going back to the idea that the book isn't about Texas. Well, I guess that seals it then. If you write a book about Mars, you can't be sued anywhere on Earth. There you go. Because your book's not about Earth. It's about Mars. Think of this. This is their argument. And a larger political debate about diversity in comics, which has no specific aim at Texas. Actually, that has nothing to do with the book itself. The book is apolitical. Paid attention. Which has no specific aim at Texas, still shows jurisdiction is not proper. Plaintiff also emphasizes AP's 210 area code, but there is no evidence this area code is so well known outside of Texas that it would typically be recognized as associated with Texas. Come on now. Come on now. Much less that Waid himself so identified it. Furthermore, while the Texas Supreme Court's decision in Michiana Easy Livin' may not be binding, the court's reasoning is directly relevant here in emphasizing that a call to or from a particular area code is no reliable indicator of any purposeful availment. Even if the defendant knew the area code was associated with a particular state in light of changes in technology such as mobile phones. This is such a bad... Michiana is such a bad case for them. Michiana should be held to be more persuasive than the out-of-state decisions that plaintiff cites. Plaintiff also falsely claims Waid stated he did not know where AP was located until his suit was filed. Waid only explained that he did not know AP's location at the time of the calls with AP. That remains true and unrebutted. Waid learned AP was in Texas after the brouhaha that erupted after AP's independent decision not to publish Jawbreakers. But that is immaterial to Waid's knowledge at the time of the calls. Well, no, he's lying. That's the problem. Waid also lied about not being in Houston to make the statements that are coming up. All right. Plaintiff cannot establish personal jurisdiction as to his defamation claim. If that last one was annoying, this is about to be the stupidest thing you'll read until maybe Toye's response. This is about to be the dumbest thing you can read. I gotta prepare myself. How do we do that? All right. We're gonna have to. That is a solid bottle of gin that is being polished off. I salute you. Oh wait, that's a finished gin. I don't think I can play that song. I apologize. No disrespect meant. Insert clever name here says, oh no, Waid has broken Nick's brain. Not as bad as this next one. This next one's gonna be really bad. All right. Plaintiff entirely hangs his case for jurisdiction over the defamation claim on Waid's statements at a convention in Houston, occurring after AP's decision to not publish Jawbreakers. But plaintiff's own complaint pleads that his defamation claim stems from statements allegedly made through Waid's various social media accounts. It makes sense plaintiff would not base any defamation claim on Waid's statements in Houston because those statements occurred after AP's decision to not publish Jawbreakers. He still made the defamatory statements in Houston, you lying dumpster. As plaintiff response states, at its base, this is a tortious interference case in which Waid allegedly interfered with a contract between Meyer and AP. Oh, well, because at the base, it being a tortious interference case and also having a claim of defamation that is, you know, next to the tortious interference, well, I guess then it doesn't matter. A plaintiff must plead a prima facie case for personal jurisdiction. In ascertaining whether specific jurisdiction exists, the court therefore looks only to the contact out of which the cause of action arises. The cause of action is going to arise from any defamatory statement. Let's see. Do I have the pleading? I think I have the pleading. Let's just take a peek. Let's just see what it says. Let's see. Okay, hold on. Through his various social media accounts, Waid intentionally published statements of fact to his followers and the general public regarding Meyer, including falsely stating that Meyer published the first and last names of comic book stores, blah, 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 as well as characterizing Meyer as a racist serial harasser of minorities and affiliated with white supremacists. Those statements were false and were published with actual knowledge of or reckless disregard for the statement's falsity. Okay, here's the thing. Texas is a notice pleading state. We've got jurisdictional discovery to specifically determine jurisdiction. So they're going to go ahead and argue now. Listen to what their argument is, all right? Their argument is they pled this. We challenged jurisdiction. We both agreed to jurisdictional discovery, but now we don't want to use the discovery to talk about the pleading. That's the that's it. At worst case, the judge will just simply allow them to amend their pleading. That's how that goes. If anything, the judge just says, okay, well, file an amended complaint. File an amended complaint which addresses the deficient jurisdictional issue of not pleading specifically about the defamatory statements made in Houston that were made well before the case was filed, but just saying they were made on social media. And even if they were made on social media, they impact him in Texas still. It's still the same thing. But I digress. Worst case, let's give them the benefit of the doubt. If they have anything here, they have Meyer going ahead and requesting an amended pleading to include the Texas defamation statements. That's it. What's the point, though, of jurisdictional discovery if you're not going to allow someone to then include that discovery? I don't know. I don't know what their plan is here. Mithran Emmer says, wait, did they really just say, my client made the defamatory statements at time Y, not time X, so ha? Isn't that perilously close to admitting he made defamatory statements at some point? Yes. Yes, it is. Okay. Okay. Though defendant may have purposefully directed the subsequent acts at Texas, plaintiffs had failed to show that any of these contacts gave rise to their claims. I mean, these are literally the same statements. He's making the exact same defamatory statements that are pled in the pleadings. He's making them in Texas. Of course they arise. As plaintiff's own pleading shows, Waid's statements in Houston are not the basis of plaintiff's defamation claim, thus leaving only the alleged social media statements. No. Furthermore, even if Waid's statements in Houston were relevant, it remains the case, which they are not. It remains the case Waid did not know plaintiff was located in Texas until his lawsuit was filed, which would still defeat jurisdiction. No, it wouldn't. If the judge was on their side, to this point, that paragraph made him say, because it's so ludicrous to assert that you're in a state, you're talking about someone in that state, and your comments are defamatory in that state, but you didn't know where they were, so then it's okay. Wait, are you serious? Are you serious? That's your argument. I mean, that is thin. Notably, discovery confirmed plaintiff never signed any contract, and AP had the unfettered discretion to decide against publishing Jawbreaker. It's not how that works, and that doesn't matter. Even if true, it doesn't matter. On substantive grounds as well, plaintiff's defamation claim is entirely meritless. Plaintiff's own pleading admits that by late 2017, media reports began to emerge characterizing Meyer as a bigot, a racist, and part of a group that promotes white supremacy. That doesn't mean you get to repeat the false claims. Doesn't mean it at all. Therefore, why did they put this insinuation repeating that premise could not be legally defamatory? That is absolutely untrue. Plaintiff's hate-filled targeting of other creators rendered his defamation claim absurd. No, that is terrible legal reasoning. Hold on, excuse me, guys. Okay, sorry about that. I was just finding my Minecraft news for later. Even if the court were to consider Waid's Houston statements and find them sufficient for jurisdiction over the defamation claim, the court should alternatively transfer that claim to the Central District of California where Waid lives, which is where the tortious interference claim would need to be litigated, if at all. District courts have the discretion, even sua sponte, to transfer actions to other districts. This lawsuit is really about his... Sua sponte means on the court's own initiative. This lawsuit is really about his baseless tortious interference claim. Keeping plaintiff's defamation claim here would result in unjustified judicial inefficiency. No, removing it to California would be unjustified judicial inefficiency. Oh, and let me point out, this document is not 116 pages. All of their submissions combined are. That's going to include the transcript of one of the depositions, as well as some supporting documents that we'll go through in a minute. This document itself is 13 pages. We're on page 7. Discovery also established that plaintiff's lawsuit is completely meritless. I mean, I don't think so, but what do you think? Plaintiff spends much of his response mischaracterizing the facts in his attempt to pursue the lawsuit in Texas. Because plaintiff's jurisdictional arguments are... Look at how much they know. They know that if they go to court in Texas, they lose. They know it. They know it. If you notice, how many... Can we find this? Let's see. Let's do this. We're going to have a fun exercise real quick, okay? So we're at the top of the document. We're at the top of the document here. And we're going to search for the term in Texas. And we're going to count them up. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 20, 26 total times. 26 total times they use the phrase "in Texas." You want to find out what they're scared of? They're terrified of fighting this in Texas. They are terrified because they know they lose. Make no mistake. Believe that. Believe that. Okay. Because plaintiff's jurisdictional arguments are intertwined with his various assertions about the merits, Waid feels compelled to correct the misleading picture plaintiff tries to paint. For example, plaintiff's response asserts that at its base, this is a tortious interference case, and then repeatedly suggests, tellingly without evidentiary support, that Waid caused AP to not publish plaintiff's book. I mean, here's the thing. Motions on pleadings are going to read this with every possible inference and deference given to Meyer, not Waid. Response at 1:12:13. Discovery not only highlighted the lack of jurisdiction, it further revealed this lawsuit to be a baseless publicity stunt. This lawsuit also violates anti-SLAPP provisions allowing recovery of attorney's fees and costs. This is a stupid sentence to include because this is conclusory. This is not legally related. And if he goes ahead and makes a prima facie case, he defeats the TCPA. This is, again, don't tell judges legal conclusions that they haven't had even arguments to rule on yet. Very, very bad. One shot for every in Texas. Hold on, let me get the hospital on the line. Oh my gosh. Hold on. Sorry, I had to check something. Okay. Plaintiff cherry picks from AP owner and decision maker Yoming Dunn's testimony to support his arguments and then astonishingly ignores explicit testimony AP decided against publishing plaintiff's book because of plaintiff's own conduct. Not anything to do with Waid. Right. Here's the thing, Pumpkin. This is a jurisdictional discovery. The only relevant arguments are those of jurisdiction, not of the nature of the lawsuit. You could have filed a motion to dismiss along with your jurisdictional motion. You could have filed a motion to dismiss for failure to state a claim or for an anti-SLAPP purpose, but you didn't. You didn't do that, did you? Why didn't you do that? I wonder. Now, I'm not a Texas attorney, and I'm not a 30-year litigator either. But your boy Zack, if you're out there, if you see this, buddy, I would ask Daniel Byrne if there's any possibility of defeating their upcoming obvious anti-SLAPP motion under the Texas Citizen Participation Act. If there's any chance of defeating that motion for failure to bring it in a timely and efficient manner. Because that's the next thing they're going to do. When they lose this jurisdictional argument, they're going to immediately file a motion to dismiss based on the TCPA. They're going to drag it out. They're going to file one motion at a time. They could have filed the motion to dismiss based on the TCPA prior to the jurisdictional discovery, or at least concurrent with it. Here's the interesting thing. That's a dispositive motion. So had they conducted a TCPA motion or an anti-SLAPP motion in Texas, they would have conclusively decided the case at that motion. I'm not sure of the rules of civil procedure, but by filing a jurisdictional challenge, which is non-dispositive, because if they win on jurisdictional grounds, it's going to be dismissed without prejudice with the ability to file in California. They could have brought the dismissive motion or the dispositive motion at the same time. I'm not an expert on this. You'll want a civil procedure expert, Meyer, but you may want to ask Daniel Byrne what their office's civil procedure expert thinks on this, because depending on the rules on that anti-SLAPP motion, they may have, how do we say it? pooped the bed on this one. I don't know. But that's certainly an avenue I would look into if I were your attorney, which I'm not. So you'll have to ask them. Next. Mr. Dunn testified he decided not to publish plaintiff's book because his own staff and close friends were disgusted by plaintiff's conduct and voiced objections to such an extent that some would sever ties with AP, and not because of anything Waid did or said. That's not how this works, and you know it. And so again, were the factors that led to Antarctic Press's there were factors that led to Antarctic Press's decision that had no relationship to Mark Waid, correct? Yes. And those factors were concern that your staff and freelancers had expressed, correct? I'm going to address this in a minute. And including Mr. Meyer's own conduct, correct? Correct. And those factors that led to AP's decision are factors unrelated to Mark Waid, correct? Correct. You made the decision for Antarctic Press, correct? Correct. And that was your decision, correct? 100%. And you made that decision voluntarily, correct? And Mark Waid, did he do anything to prevent AP from publishing Mr. Meyer's book? No. Knox v. Taylor. Knox v. Taylor. It doesn't matter if they had already decided to not publish the book, but hadn't canceled it yet. It doesn't matter if they had the right to cancel the book under the contract, as long as they hadn't canceled it yet. All that matters is, was there an interfering action that a reasonable person, regardless of what the breaching party says, was there an interfering person who made an action that a reasonable person would conclude interfered with the contract? That's what matters. Don't lose sight of that. Knox v. Taylor, Texas, 2009. Landmark case on tortious interference in Texas. Good luck. Good luck. You're gonna really need it on this one, because you know that it doesn't matter because they hadn't canceled the book yet. And the argument is the straw that breaks the camel's back. Well, what straw? Well, we don't know. So any action prior to the cancellation of the book could be tortious interference. All you have to do is convince a reasonable jury that that action could have been tortious interference. We have no evidence, as far as I know, that Joe Dunn had decided to cancel the book prior to Mark Waid's call. Zero. Mark Waid's call comes in, that all changes. We'll find out in a little bit. Yeah, so there's a GoFundMe for your boy Zack. You could check that out if you're interested in helping him build his war chest. So I don't know how much of it is left, but I know that no matter how much he has, it's not enough. It won't ever be enough. Their whole purpose, as you can see, is to merely cock block and cost money. That's what they're doing. It's obvious. They're to try and out money Meyer. So consider supporting Meyer's GoFundMe. Consider funding that. I hate asking you guys to do all this stuff, to consider all this stuff, because obviously you have limited resources. There are multiple causes that are important. But yeah, give it a consideration. All right. All right. Next. Hey, what's up, Ethan? Thanks, buddy. Thank you. After AP announced it would publish Jawbreakers, AP learned plaintiff had revealed the identities of stores that had decided against That's a little disingenuous, isn't it? That's a little bit disingenuous, isn't it? the identities of stores that had decided against carrying the book because of plaintiff's well-earned reputation for harassment and hateful rhetoric. Who spread that reputation, you lying sack of garbage? AP's social media director reported to AP staff the plaintiff had promised not to rat out these retailers, and Mr. Dunn expressed hope that plaintiff would respond in the proper way. But plaintiff did not respond in any way that could be called proper. Instead, he publicly ratted out the stores by tweeting a private Facebook chat and even openly encouraged his Twitter followers to research and reveal the identities of the store employees. Here's his tweet. Let's see if it's true. I did the research on about 4 or 5 of them, but yeah. Oh, wait. Let's read the reply. Can someone put their organization or business names next to who they are? As they say, sunlight is the best disinfectant. I think we need to start dragging these cabals into the light. They're clearly talking about the store identities, right? Store identities. Can you guys not see the link to Myers GoFundMe? I'll put it up. I'll put it up. Here we go. Where is it? Okay, just a second. Just a second. Copy link. Here I'm spamming the oh my gosh, what a disaster. Let me get it to let me get a cleaner link for you guys. Here we go. I don't know why some of you can't see this. But here we go. Let me pull this up. Here's a clean link to it without going through the YouTube thing. Lots of people are posting it in the chat. I'm spamming it in the chat right now. Enjoy it. Love it, live it. So there's the link there. So Diversity in Comics says, I did the research on about 4 or 5 of them, but yeah, if someone could go through these screenshots from that retailer Facebook group and make a list of the people, the stores, make a list of the people, the stores they work at, and the cities, that would be great. Yeah, trying to find the stores. The list of the people is already from the Facebook group. Like, that's already there. They put their identities in that Facebook message. Mr. Dunn ultimately became aware of this spiteful effort. The spiteful effort. We're not going to carry your book, and we're going to ruin Antarctic Press. Ooh, I switched from gin to proper 12. Surprising, because I forgot. As plaintiff had requested, one of his followers publicly listed the name of store employees and related phone numbers. Not content with this, on the morning of May 11th, plaintiff also retweeted an apparent threat of violence against those stores and praised his incel army. Yeah, it's a joke. It's a joke, and you know it. Don't carry jawbreakers. Say hi to the leg breakers. To me, my incel army. Yeah, come on. Come on. All this occurred before Dunn ever spoke to Waid. And yet, Dunn had decided to publish the book. Listen to where they're lying. Where's the lie? Where's the lie? The lie is Dunn, up until the moment Waid called, as far as anyone can tell, Dunn was still publishing that book. After announcing its decision to publish Jawbreakers, AP also came to learn about some of the shocking comments plaintiff had made about other creators. Among other things, AP's editor-in-chief, or EIC, reported to Mr. Dunn that he had learned that plaintiff had called his Star Wars editor a cum dumpster. Well, maybe she shouldn't be a cum dumpster then. Has she considered not being a cum dumpster? I have said cum dumpster because of these people more times than ever before in my life, which was 0. But these people have made such a big deal. These people have called this woman a cum dumpster far more times than Meyer ever did. It's insane. This was in addition to other horrific, listen to the pearl clutching going on from these cum dumpsters. Horrific statements plaintiff made in a YouTube video, including defaming Waid and others as pedophiles. Lie. That's a lie. That's actually a lie. And I know that this is the response to Meyer's response, so he doesn't merit a response. But that statement right there actually might merit a response, because that is a gross misrepresentation of what he said. He did not defame Waid and others as a pedophile. He did not call them pedophiles. He says they look like pedophiles. That's a vastly, vastly different statement. And that is a flat out lie in their motion. And they have a duty to correct it. Just as they had a duty to correct the fact that Mark Waid was in Houston making these statements. You liars. You're lying to the court. Stop lying. Plaintiff never revealed this YouTube video to AP. That's because it was private. It was a private YouTube video that got leaked by someone else. But AP learned of all this before Dunn spoke with Waid. And they still decided to publish the book. How are you going to get past that one? AP's EIC found plaintiff's conduct so egregious, he sent the following email to Mr. Dunn before Dunn ever spoke with Waid to make clear that he did not want AP associated in any way with plaintiff. I'm honestly not sure you understand what you're getting into. I was at the comic book store and even Bob said so. He said, if Joe thinks this is going to blow over, it isn't. Well, Bob, you know who's the expert on what's going to blow over on social media? It's Bob, the local comic store owner. The one local comic store owner. That's the expert. We got to listen to Bob. I thought about it long and hard. You sick, sick man. I haven't been able to sleep or work. That's because you're thinking about long and hard things. Come on, buddy. And that's because it boils down to this. Long and hard. I'm not comfortable being associated with this guy. It's not his work and it's not his beliefs. It's his conduct. And if it were any of the other guys at AP that conducted themselves similarly, I would divest AP of them as well. There's standards of civil and professional conduct I believe in. This guy obviously has issues. I've told another AP employee to take my name off the books immediately. And I'm also worried about how this may affect other AP creators in San Diego and the booth. Let's be honest here. Nothing could negatively affect other AP creators other than their own work. I mean, I'm not trying to be rude, but they're selling no books. They're selling nothing. So it's not like Meyer is going to drive down sales that are basically non-existent. I mean, I'm just saying. Just saying. Mr. Dunn found this message to be a big deal because his editor-in-chief is also a good friend, almost family. This is a big deal. He's my good friend, almost family. His editor-in-chief wanted AP to remove his name from all books published by AP if it were to publish plaintiff's book. Okay, remove his name. Who cares? AP's editor-in-chief was not the only one associated with AP who strongly objected to doing business with plaintiff. None of this matters. None of it matters, and you know it doesn't matter. Why? Why waste pages? Mr. Dunn testified that, quote, everybody at AP had concerns about publishing plaintiff's book after his conduct had come to light. Who brought it to light? Who brought it to light? Who focused on it? With one creator even pulling his project from AP. Again, how many sales? What are we talking about? AP was in the financial dumpster. The financial cum dumpster. That's where AP was. Just swimming in it. Just swimming in it. Mr. Dunn confirmed the accuracy of the following May 2018 statement by AP regarding its decision not to publish plaintiff books. Ultimately, some of our staff and freelancers were uncomfortable sharing a platform with anyone who makes disparaging remarks about anyone in this community. We had to cut ties. We wish Richard all the best. Doesn't matter. Doesn't matter. Knox v. Taylor. You know it doesn't matter. AP was justifiably concerned that publishing Jawbreakers would associate AP and its people with plaintiffs' hateful hateful rhetoric. In light of all this, Mr. Meyer's own conduct led to AP's decision, not anything Waid did or said, except for the fact that was confirmed in deposition, and as far as anyone can tell, that prior to Waid's call, up until the moment of Waid's call, the book was still being published. The book was still being published until Waid called. Period. Mr. Meyer's own conduct led to AP's decision, not anything Waid did or said. Confirming that before he spoke with Waid, Mr. Dunn felt like he didn't want to continue down that pathway of publishing plaintiff's book. Felt like it. Didn't cancel it, though, did he? Confirming factors that led to AP's decision are factors unrelated to Mark Waid. Yep, factors. Not all of them. Not all of them. And then finally, testifying that Waid did not do anything to prevent AP from publishing Mr. Meyer's book. That testimony literally doesn't matter. It doesn't matter. I can't state it enough. Here's the thing. A breaching party's reason for breach is given zero credibility in Texas. Because they breached. Here, footnote 8. Plaintiff puts Mark Waid's weight on the fact that Mr. Dunn texted Waid soon after AP made the decision to not publish the book. But Mr. Dunn even poured cold water on plaintiff's suggestions around this. Mr. Dunn explained he did not realize he was even texting with Waid. Come on now. That's not exactly how that went. But was confused and thought he was texting with someone else because he had been communicating with many people in this time frame. Plaintiff also relies on testimony from Ben Dunn, but Ben testified his brother Joe never shared with him information about the call with Waid, and therefore his observations related to the call are merely speculation. No, that's not true. Okay. Gosh, this is a frustrating document, guys. Not only is it clear Waid did not tortiously interfere or otherwise cause plaintiff harm, plaintiff's lawsuit is baseless for other reasons. As noted above, plaintiff never signed the proposed contract. Texas doesn't need a signed contract, and you know it. And even if there were a contract, AP had the discretion to decide against publishing jawbreakers, thus defeating any necessary breach. No, 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 no. No! The case law says specifically that even if they have the right to breach or cancel, which isn't a breach, up until the moment of cancellation, up until the freaking moment of cancellation, tortious interference is possible because they might have changed their mind. And you won't know it. You can't know it until they cancel the contract. Mither Nimmer says, if we are going to play the guilt by association game, Waid is a sexual harasser and pedo since James Gunn directs Marvel movies and Waid worked for Marvel. He associates with degenerates. See how that works. Dunn also testified plaintiff's possible damages from AP's not publishing jawbreakers would be $1,500 to $10,000 at best. That doesn't matter. They actually don't know. They don't know. They were talking about doing second and third books. They're talking about multiple books, and because of this, he's suffered other damages, and you know it. This suit is a publicity stunt, which, if pursued at all, cannot be pursued in a court in Texas. What they're trying to do here is subtly hint at defeating the $75,000 requirement for diversity jurisdiction. But they're not challenging diversity jurisdiction, so this statement is completely ineffectual. Completely pointless. This suit is a publicity stunt, which, if pursued at all, cannot be pursued in the court of Texas. Conclusion and prayer. Waid prays, no he doesn't, you liar, that the court dismiss plaintiff's lawsuit pursuant to Rule 12b-2. Defendant further prays for such and other further relief as to which he may be justly entitled at law or in equity. Signed, Ryan Pierce. Ryan, come on! Ryan, that was just a trash document. Hold on. Come on, Ryan. Just a real shame. Ryan's been practicing a long time. Again, I'm really working. I'm trying. I'm trying. Give Ryan the benefit of the doubt on this. I'm trying. That's a bad argument. He's got to know. I mean, he's got to make it. I don't know how to reconcile that. He has to make the argument, but it's a bad argument. Where's Zaid? Zaid is their super lawyer. Their ace in the hole. The best lawyer on earth. He has not signed a single document. Where is he? Didn't say a word during deposition. Where's Zaid? Why is Ryan doing all the work? All right, let's read some of these chats. I'm telling you, the gin plus the whiskey, premium buzz creator. All right, CC 1138. Excited to see more of Waid simpering tonight. By the way, did you happen to see that comment I left on the last vid about Rachel Butera? No, I didn't. Sorry. I'll have to maybe try and find it. Patrick Thompson says, hey, Nick, did you see that Mars Girl went after Vic's mother today? No shame on the kick Vic side, especially after Ty promised Vic's mom. Yeah, interesting. Interesting that they'd go after her now. But again, poke the bear. Poke the bear, I guess. I guess that's your plan, is to poke the bear. Oh. 2012 Jameson says, can you explain hearsay? I might keep some of Ron and Beth's testimony out of court. Feel free to rant. Hearsay is actually a very complicated rule of evidence, and no, I'm not going to explain it in depth here. The long and short of hearsay is the person asserting the statement to prove something as true or false has to be the origin of the statement. That's the long and short of it. So, Ron can't say, so-and-so said this. No, where's so-and-so? Why aren't they in court saying it? If they said it, bring them in to say it. That's hearsay. Ron says, so-and-so says this, which proves this. If that happens, that's hearsay, and it doesn't help. It doesn't work. The judge will... You can object to it, and the judge will exclude that evidence. There you go. JMD Reed says, Betteridge's law of headlines. Any headline that ends in a question mark can be answered by the word no. Are you making fun of my yeah. You're making fun of my title? Don't make fun of my title. Nick is buzzed. This is true. This is true. Coyote Briggs. Nick, a friend of mine got hit really hard this month. Lost job and car broke. Set up a GoFundMe. It's $225 short. Could you retweet it? Every penny counts. Sure. You gotta tweet it to me or something, I guess. I could do that. Or post the link. I don't know. Alan Grant, thanks for the donation. Sakaki Onsai says, Leighton Wade. Andrew War Snowboard says, eat a Minecraft jelly bean, Monica. Automata says, anticipated and fabulous. Meximan and Cheese says, Nick, stop Rama and start the show. Drayfon, thank you for the donation. Solo Beverly says, Leighton happy. Areva says, Leighton really gay. Andres Angulo says, first time Nick, big fan of you, and Ty, always watch. Awesome. Thank you so much for letting me be your first time. Mithra Nemmer says, your continuance was denied, counselor. Explain yourself. Just kidding, Nick. But you were Leighton Wade today, verging on becoming Soye. Massive Damage Gaming says, tardy, homosexual, and silent SMH Rick Nikeda. No one important says, just want to say you're right about letting them keep talking. Today's post has got to be his most dumb one yet. Good on you, sir. Ichicinco Negroni says, was out of the loop since Wednesday. What did I miss? Beige Devil says, I hope Vic burns them all to the ground. Root and branch. Lil Poo Poo says, your contact for Monica is Monica Black, isn't it? Wouldn't that be funny? Wouldn't that be funny? Deleted account says the chat stream is on crack. Too drunk for this. Too drunk for this. Finn Frog says stop generationalizing him. It's rude. Oh, thank you for defending me on not being a boomer. Every game played says it seems like whenever a spotlight is put on these people, they start acting crazier. They do not realize that everything is archived with thousands of people looking at what they're doing. Go. Talbot Link says, blood for the blood god, warm milk for the kiddos. Mithrin Emrys says, the court has reconsidered its denial of your continuance. We have decided to grant it due to the extenuating circumstances of a rogue child. Thank you. Nichols in Minecraft says, all hail late and gay boomer king. Press B to hail. Alan Grant says, the only broad spectrum here is Mark Wade's terminal autism. Keep up the good work, rackets. Gur3009 says, oof and yikes is soy boy language. Yikes especially, man. Yikes is... They've ruined yikes. It was my, it was Wile E. Coyote. DCV Titan says, this stuff right here is an argument for abortion. Anthony De Hoyos, thank you for the donation. Moist John says, need you to be disbarred by Google for tardiness and homosexuality, not disbarred by Minnesota. Areva says, to the chair for doing an amazing job. Chair Coon is really a wonderful co-host. Chris Nemo says, this is my thanks for dropping in when I was arguing with that guy who said you violated your lawyerly obligations by poop talking Renfamous. Well, that's the problem, is that these people are dumb. Kevin C, thank you. Citizen Napa says, as always, we live in a clown world. Honk honk. CE says, Nick, okay, good night, sweetheart. Tiptoes out, vault door, bam, kid, rockets to ceiling. Deleted account says Mars Girl is a fat, irrelevant, eat beast, call EPA. That guy says, you don't mess with Vic's mom. Yellow Flash 2 says, I'm so excited for the Mars Girl stream. Yeah, me too, buddy. Ghost of Nick's Beard says, I don't want your life. Neil Purcell says, challenge, watch Mars Girl's YouTube videos. No. Kiwi Goes Live says, never forget, Mars Girl said Final Fantasy 14 1.0 was okay and the fans were the problem. P.S. It's pronounced Kiwi. Tug got it right the first time. That's... Anthony De Hoyos, thank you for the donation. Agent Bum says, would like to hear your opinion on the Quinault Indian Nation suing Valve. Can't post a link, but look up Quinault Indian Nation versus Valve. I'll try to remember. John Doe says, let Mars Girl be henceforth known as Mars Girth / Gunt. Mars Gunt. Rolana 1 says, does that mean Mars Girl has a join the party from Ty Beard coming? I don't know. We'll see. Chris Nemo says, smash that like button for Tyrone, like Tyrone smashes Real. Cowboy FMJ 91 says, hope you had a good Easter with the fam. I did. I like the Spike Man says, 14 years and 88 days sober. Hope the night goes well. God bless you. And middle finger to pull for legal reasons. That's a joke. DCV Titan says, dig up the corpse, pee on it, and bury it face down. War Snowboard says, the 17th pick of the draft is going to be OBJ to CLE. Solomon Grunty says, Jew Rapio. Ooh. Is that the bunch of Lost Boys standing around go, Rapio? Rapio. Oh my goodness. Oh my goodness. We'll do a couple more, then we'll get to the next document. Plum Logan says, are the consummate unprofessional shirts up yet? No variation on a theme. They're coming. No one important says, careful, Nick, a certain cheer lover might gasp tweet offensively at you for fat shaming again. Well, Shane is the fattest person in the room. So there you go. If only gravity would equate to attention, Shane would be rich. Quantum Video says, hi Nick, you're late tonight, lol. Please mention my YouTube channel, Quantum Videos. Lots of great video game and faith-based content. Have a great night. So guys, check out Quantum Videos. Extrovert ED says, did you know Vic's mom was head nurse for the Steelers during the Super Steelers era? Be a Shane if Mars Girl riled up hashtag Steeler Nation, huh? Well, now I have to be opposed because was the Super Steelers era the Houston Oilers era back in the early 80s? Because Earl Campbell's my boy. Deadpan115 says, take my free money. Thank you. Future Gadget Lab member 001 Uwain Kuyame says, Broly's power is maximum. Kodiak says, dude, Mall Shinobi is a preferred nomenclature. Persona MC231, how do you think this compares to the Maddox case? Maddox cases was dealt with by an incompetent attorney, and for all I can tell, these are competent attorneys with bad cases. That's a big difference. Intimidator 0108 says, glad to hear you got things with what Mr. Soye said recently. If you look up the word delusional, you'll see Ron's picture next to the description. Known Important says, they are either very sheltered, very dumb, or secretly, though very transparently, very malicious people, or some semblance of the three. I think heavily on the third. And Charlie Lilly says, I told my sister about this Vic thing, and she asked me what sitcom I was watching. Love your streams. And Asphyxiation says, Nick, your next vacation needs to be Australia. I can show you and the family the friendly animals. Also, how to avoid drop bears and blue bottles. Man, that would be great. Darth Bobcat says, have your kid tell a story like Tug's daughter. And then Devil Hunter Nero. This is the last one I'm going to do for a little bit. Says, hopefully Mars Girl's tweet today is like when Frieza killed Goku's friend Krillin on Namek. Goku went Super Saiyan, so Vic will finally allow Tai to go full scorched earth on Kick Vic. Love the show, Nick. Wouldn't that be great? Wouldn't that be great? Fully gloves off. Fully gloves off. Okay. Mary Ford. I missed this one. Sorry. If we're clickbaiting our boy Zach, this is a reminder that our boy has a GoFundMe for his legal fees. Again, yes, I'm going to tweet them again. Or not tweet them. I'm going to drop them in the chat again. Make sure to go check out your boy Zach's GoFundMe. Check that out. Thank you, Mary Ford, for doing that. Brian Doig says, what do you think the odds are of Vic letting Mr. Beard take the gloves off after they went after his mom? Increasing by the minute. Increasing by the minute. Why are you going after someone who has $142,000 in his GoFundMe for legal fees to just go after people like you? Why would you go after that? Oh, 143,000 we've hit during the stream. Thank you so much. Why on earth? Why on earth would you subject yourself to that? Okay. Let's read some of these exhibits. We'll see how long I can go tonight. We'll see how long. The proper 12 following the gin. Hitting a little tough. I didn't have... What did I have? I had some chicken fingers from Raising Cane's at 1 p.m. Starving. So the liquor is hitting a little bit extra hard tonight. This is the declaration of Ryan Pierce in support of defendant's motion to dismiss. My name is Ryan Pierce. I am over 18 years old, of sound mind, and am capable of making this declaration. The facts stated in this declaration are within my personal knowledge and true and correct. I'm an attorney with the law firms of Reeves and Brightwell. I represent defendant Mark Waid in the above referenced proceeding. In that capacity, I'm personally familiar with the pleadings on file, discovery, and other conduct regarding this lawsuit. Documents attached to this declaration are true and correct copies of documents as further detailed below. Court order allowing jurisdictional discovery expressly allows Waid to submit evidence obtained from the discovery as part of his reply. Attached as Exhibit 1 are true and correct copies of the excerpts from March 6, 2019 deposition of Joe Dunn. Exhibit 2, true and correct copy of deposition Exhibit 25 from the March 6 deposition of Joe Dunn. Certain information has been redacted for privacy. Attached is Exhibit 3, a true and correct copy of deposition Exhibit 27 from Joe Dunn. And Exhibit 4, true and correct deposition of Exhibit 28 from Joe Dunn. All these are from Joe Dunn. I'm not going to read all of them. Except for Number 13, attached is Exhibit 10. True and correct copies of excerpts from the March 6th deposition of Ben Dunn. True and correct copies of excerpts from the February 26, 2019 deposition of Mark Waid, with the crying redacted. I declare under penalty of perjury, the foregoing is true and correct. Executed in Travis County, state of Texas, April 22nd, 2019. Ryan Pierce. Look at that signature. What even is that? You can't spell rape without R and P, Ryan Pierce. It's a joke. That's a joke. That's maybe a drunk joke. Okay. Exhibit 1. Oral deposition of Joe Dunn. Didn't we go through this? Woo. It's 1 in the morning, guys. I might have to. We're getting to the point where Daddy Nick might need to go to bed. All right. Okay, this is the initial stuff. Joe Dunn. Did they post the entire... Hold on. Did they post the entire transcript unredacted? My God. No? Wait. 68, 57, 56, 55, 52, 50, 44, 43, 36. Oh my God, what a disaster. Okay. Let's skip these first pages because we did read these. Wait a minute. Who's asking the questions? Burn. Okay. We're going to skip to page 31 here. Sorry. I know the scrolling is really obnoxious, but I'm sorry. That's what I got. I did switch to water. I ran out of Oh no, all the letters of rape are in Ryan Pierce. No, Ryan, why? Ryan! Now wait a minute, Ryan, no! I switched to sweet tea a while back. 2 drinks is not supposed to do it. But again, I'm starving. Matt Squared 2 says, "Hey Nick, second time chatting on your stream. I don't know how you do this stuff so late on a weekday, my man, but let's share a drink. Bottoms up, buddy. Keep up the good work." Oh, I've shared all the drinks already. All right. Let's get through this deposition of Joe Dunn. And we might have to pick this up tomorrow. So we're going on page 31. I skipped the first 14 pages because first 14 pages are, you know, we covered them. We actually covered. Look at them skipping 12 to 14. We actually covered them in the other video. Maybe you need a guest right now. Maybe I need a lot of things right now. Okay, are they typically located in Texas or at various locations around the country? The ones I've attended are in Texas. Have you ever seen Mr. Waid present at any of those conventions? No. We actually read this one too. Set up a booth. How would attendees at conventions come to know? What would they learn about Antarctic Press in the course of seeing a booth for you? Objective form. Typically at a booth that we attend. Okay. What is it that you attempt to convey about your company by setting up a booth to the people attending the conventions? We set up at conventions. We try to reach the audience that attends at conventions that may be comic book fans in hopes to attaining new fans. New customers? Yes. What is it that you convey about yourself? Typically sell the books that we publish during that period of time, and if possible, to have creators attend our booth to meet with the fans and potential customers. You convey that you're a Texas-based publisher in the course of these promotions. Notice they're using the answer that they objected to. That'd be funny. They should agree to that objection, have that answer stricken from the record. Just kidding. You can't really do that. Can't do that. Typically not. They don't say they're a Texas publisher. We got that from the other stream. I'm going to skip forward to page 36. Is that the only office number that Antarctic Press has had at the time? So the San Antonio number. Correct. And that's a landline. Correct. You recall getting the message relayed to you about Mr. Wade's inquiry. Typically, Doug answers all the phone calls, and so my suspicion is that Doug answered the call. Okay, at the time that the message was received, do you have any recollection of where things stood in terms of the buzz or controversy concerning the social media activity since the announced decision to publish Jawbreakers? I recall at that period of time there was quite a bit of information coming to me from a variety of different sources, but I was gathering information mostly from people that I trusted the most, which was Brian and Joey at the time. As information was being gathered, that's when Mark's phone call came in, and when I responded to his phone call. So this doesn't actually help their case. I'm not sure why they decided to include it, but I think they're trying to focus on Brian and Joey being the primary sources of information. But that's when Mark's phone call came in, and I responded to his phone call. Next, we skip to page 43. Did you have the Captain Kirk solution fashioned yet? That's the solution of the Kobayashi Maru? Kobayashi? I've got to be getting that wrong. The impossible Starfleet solution, right? The Starfleet solution that is an impossible thing that only Captain Kirk was able to beat. No, I didn't have the Captain Kirk solution fashioned yet. You make reference to social media pressure. What was the social media pressure coming in both directions? Yes. Notice they're objecting to all of this stuff. Now, in the second paragraph, you make reference to, I'm going to rant, not to each of you personally, but to everyone who has put us in this situation. Was this being circulated beyond just Joey? No, it was just between me and Joey. Obviously, you use a lot of powerful language here. Oh, wait, no, he doesn't answer. Oh, wait, he does. Sorry. Mr. Dunn, I don't need to go through it with you line by line, but at the end of this email, are you still, at least at this point, standing by your decision to proceed with the publication? Objective form. I think by the end of this rant that I did in this email, I had felt that my emotional status had been drained. I felt like I didn't want to continue down that pathway. That's when Waid says yes. That's when Waid says yes. Waid is not supposed to speak during deposition. Way to be a stupid idiot, Waid. Let's go off the record and then they come back. But here's an important thing. Wait, let's do it this way. That is not canceling a contract. I can't stress this enough because of how important this point is in a TI case in Texas. I felt like I didn't want to continue down that pathway. You haven't canceled the contract yet. Lots of people continue with contracts that they feel like they don't want to continue with. Right? We've learned this from the Vic situation. You might not want to continue with the contract. You might have to because you made a contract. Okay. Let's see. Now we skip ahead to 50, so I'm going to skip the rest of that page. Not important. You're worried that if you stuck with your decision to publish, that might alienate Joey. Well, Joey's a cuck. I mean, can we just get this out there? Joey, you're a weepy vagina. Go home. Go away. No one cares about you. Even Mr. Dunn. I mean, he probably does. But seriously, stop being such a pansy. These people, the people that won't buy the book because Meyer said come dumpster, wouldn't buy the book anyway, and they probably already hate you because your name is male. Let's be honest about this, Joey. None of them like you. They don't know you. They never cared about you. They won't care about you before this. They won't care about you after this. No matter how much you don't want to publish Meyer's book, you're advocating breach to your boss, which is stupid and cowardly and unmanly, and women don't want to sleep with unmen. I don't know how else to tell you this, but your position on this is embarrassing to all of the rest of us. Let's see. Turn to Exhibit 7, this deposition binder. If you can. First of all, just if you can, if you're able to. First of all, just let me ask you to generally confirm this series of text messages between your cell phone and that of Mr. Mark Waid that took place between, well, in May of 2018. I do remember this. Is that in fact a series of text messages between you and Waid? Yes, but I'm going to make a clarification. I was texting and responding to a lot of people, and I'm actually not. I thought this was somebody else when I was texting to some of these messages, I think. Well, that's useful. And so I can't remember who I was talking to at the time, but there was a whole bunch of texts that I was responding to a variety of people, and I don't think that I was aware that this was Mark Waid until later on. And then on these series of texts, notice when he realized that it wasn't Mark Waid was when he said, "I'm not going to talk to you anymore, you bully." I realized it was Mark. I said that I'm not commenting anymore. Oh yeah, he says it right there. I said that I'm not commenting anymore. So next, we skip page 51, bafflingly, and go to 52. So are you thanking Mr. Waid for talking to you that afternoon in this text? Like I said, I don't think so, actually. I think I was talking to somebody else. Who else did you think we were talking to that afternoon about I talked to a multitude of people, or texted a lot of people, and I think, like, one of the people was Timothy Lim, who was at the time friends with, and Timothy Lim, horrific, horrible racist. I think we all know that from Comicsgate. I'm guessing still with friends with Mr. Meyer and my brother, your brother. Well, my brother was there, so I guess I was talking to him at my house. I remember talking. Come on, Joe. You're saying you maybe texted your brother. He was in the room next to you. But I remember talking to a whole bunch of different people, texting a whole bunch of different people, and I may have been confused as who I was talking about at the time. You're at your house that afternoon? Yes. Do you have a landline? Yes. Do you have phone records for your landline? No answer. We skip to 55. Your cell phone, when you dial in, a text message does pop up the name of who you're communicating with, correct? Object to form. Why? Why are you objecting that? Yes. Do you have an iPhone? Yes. Okay. But at the time, I was getting calls and texts from a multitude of people. Right, but Mr. Waid has validated Exhibit 7 as an exchange of emails between his phone and your phone. Object to form. You don't disagree with that, do you? Now that one should be objected to, because how would he know what Waid is validated? I don't disagree with that, but I think that some of my text too, it was not intended for him, I don't think. And then when I realized that's when I said to him at some point during the message that I realized I was texting the wrong person. Then I said, "Oh, I don't want to talk to you anymore." Mr. Dunn, what is it about this exchange here that is inconsistent with you having text conversations with Mr. Waid in May of 2018? Object. It's argumentative. No, it's actually not argumentative, and you can't object to argumentative grounds in Texas depositions, and you know it. An improper objection. I'd come to the realization that I didn't want to deal with the situation any further, and I was letting some people know that's what my decision was. Who else would you be texting with about being prepared for a lashing from the other direction besides Mark Waid? At the time, I was talking to Timothy Lim quite a bit. Is Timothy Lim in your contacts? Yes. Now, there's a change in the tone of your text in this exhibit starting Tuesday, May 15th. Do you see that? Correct. I'm not commenting anymore. Right. That's when I think I realized I was texting the wrong person, responding to the wrong person at that time. I didn't realize that was Mr. Waid at the time. Why didn't you say, "I didn't realize who I was talking to" in your text? Object to form. At the time, I didn't want to deal with anybody associated with the situation, so I decided I wouldn't respond to anybody. I wasn't going to respond to anybody. I wasn't going to talk to anybody, and I, since that period of time, I've been consistent in that I've not talked or to mention this to anybody. Tell me about the conversation you had with Mr. Meyer after your decision to terminate the publication. I didn't talk to anybody. Tell me about Mr. Meyer. Are they going to include all this? I bet not. Why not? Notice this. Page 57 to page 68. Why didn't they include his conversation about what he talked to Richard Meyer about? Remember, now, normally I would say this is just a jurisdictional argument. This is just a jurisdictional argument, right? We don't care about the substantive matters. We care about the jurisdictional matters, and other stuff is irrelevant. However, the defense has raised that this shows the case to be frivolous. Why are we missing pages 57 to 68, or 58 to 67, I guess technically? Why do you think that is? What do you think is in those texts between Joe Dunn and Meyer following cancellation of that project? What do you think he said? Do you think that's going to come out in actual discovery? Because I do. David Redondo says, I thoroughly enjoy your content and the delivery. Priceless. Keep it up. Oh, by the way, I'm drinking Green Spot. Good job, buddy. Good job, buddy. All right, let's wrap up this page here. After the decision, after, you know, getting all the information that I gathered in regards to the situation, I knew that I was the buck stopped here type of person about making a decision. I also realized the passionate nature of some of Mr. Meyer's followers, but I was just asking you about what you talked about. You said you had a phone call. Now, I don't know if you guys know or remember this, but Meyer posted a video. He took it down later. And that video talked about what was in that phone call between him and Joe Dunn. The video talked about the abuse that he got from Waid's people, not Meyer's people, Waid's people, about the fact that he felt bullied, I believe was the line from that video. But you'd have to check. I don't remember. I don't know if someone archived. I don't know if somebody archived it. But it would be interesting to find out what was on those pages, those missing 9 pages. Let's take a break. We'll pass the witness. Okay, now we're on to new stuff. We're on page 18 of 60. I'm going to go 15 more minutes, then we're going to do chats, then I'm going to be done. Okay? Wait, actually, no. No! How dare you? Let's resume this tomorrow. I'm going to do chats now because we're switching from their perception of what Byrne said. Now we're switching to Pierce. This is all new. So we're either going to do it. Oh, God. Can't. My highlighting is terrible. Get rid of that. Get rid of that. Let's do this. Tomorrow, we're going to resume here. Unless something major happens or unless Christina is available tomorrow but not Wednesday. I don't know. But the next video we do on Waid versus Meyer, which is going to be in the next couple days, either today, tomorrow, or the next day, we'll pick up right here. I'm going to do chats, and then I gotta get some rest to get this sore throat taken care of. So I apologize, but I gotta do it. Let me let's hit these justice chats. Come on now. Come on now. These justice chats that I've kind of left from the beginning. God. Here we go. Knight of Hopex says, I heard Monday Matt is trying to latch onto Vic and his fans. Keep that clout-chasing, self-loathing mama's boy away from Vic and Ty. That clown isn't worth the carbon he's printed on. Maybe I'll have Mundane Matt come on the show. I don't know if he'll listen, but I'll invite Mundane Matt on the show to talk to me specifically about his positions on Vic. I think that'd be fun. We'll see how much Mundane Matt knows about the subject and knows about the law. Okay. TLJ Screwjob says, hey, Nick, going on my first ever date tomorrow. Congrats, buddy. Her mom and my mom have been trying to set us up for a few months now. Any advice? No, I'm the worst dater ever. Terrible at dating. Ask Lady Rackets. I suck at it. Just go somewhere, eat, talk to her, be you, but be the best version of you. Hope that helps. Also going to ask the High Council of the Star Wars Fandom Menace for advice, which EVS is on tomorrow if it goes well. Attaboy. Just go get it. Just go get it. You're going on a date with her. You're past the majority of stuff. Relax. That's okay. That's the advice I can give you. Relax. Major Spikeball, thanks for the donation. Victor Finnegal says, we're the no Judeo people's front. We're the people's front of Judea. There you go. Cooper the Whooper says, greetings from New Zealand, Nick. Hey, thanks, buddy. This whole Vic situation has been a roller coaster, and I'm glad to see and learn about the American legal system. I'm hoping he comes out on top. Knowing he has legal remedy makes me think America, F yeah. Thank you. Hey, thank you, buddy. Thank you. And thank you for being a New Zealander who doesn't hate me because of the Christchurch stuff. Lord of S'more says, hey, Rackets, glad that GoFundMe is going well. Wish I could get even 1% of the support on my GoFundMe. Trying to get together the money to move after foreclosure. Hashtag I stand with Vic. That's tough, man. That's tough. Everybody, I guess, check out Lord of S'more's GoFundMe. See if you'd be willing to help out. DP694377 says, malice B-word. How dare you use profanity on my stream? How dare you use profanity on my stream? You know that is not allowed. Not allowed here. Okay, Nightmare X123 says, I hope they don't settle. I pray they don't settle. No one important says, 100 people violated equals I don't know anything Ron equals Ron. Yep. Amazing how that works. Shan B says, maybe Monica's security is an innocent. He just wanting to get paid. Oh yeah, nothing wrong with him trying to be security. Everything wrong with how stupid they were for hiring that pathetic thing to be security. Finfrog says, Mars Girl is Alf confirmed. I like to eat cats. I forgot. Alf ate cats. Mars Girl eats cats. Well, look, I'm just trying to get a meal, a good meal. I don't know what else to eat. Shan B said, oh wait, sorry. Mark Frazier says, Nick, how do you feel about mainstream news coverage of Vic? I only read Variety. That one was pretty good. I didn't read Newsweek because it was embarrassingly bad. And I didn't read the other ones. Kota Fujiki says, I've heard Ron and Shane are competing for world's biggest idiot of the century. Who do you think will win? My bet's on Shane. My bet's on Ron only because Shane never wins anything. Shane never wins anything. Why would he win this? Steve DeJohn says, Nick intensely leans into Mike. Boy, that'd be a real shame. Oh, wait, sorry. Boy, that'd be a real shame if you were a vile piece of putrid garbage, you dirty, dirty garbage can. There you go. DKRE says, sent you a DM on Twitter with info on Vic's case. Thank you so much. Stuart Postma says, hey, Nick, love the show. I'd like to talk to you sometime about the differences in the liquor law between Alberta and Minnesota. Also, it's post-MA. 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 Go. Yeah, that'd be interesting. M says, Nick's eyes are bluer than Soye's balls. Pass it on. Come on. I'm way too into that. I'm way too into the liquor for that. Let me put it that way. Automata says, so the simple thing to do to not hit any ethics issues as a lawyer is to avoid doing anything that Avenatti did. Avenatti still has his license at the moment. Now, granted, if he gets convicted on any of those fraud or stealing money things, then he's done. But look at Cohen. Cohen keeps his license up until the moment that he pleads guilty to perjury. Then it's gone. Avenatti, right now, until he's convicted of perjury or the convicted of stealing his client's money, he still has a license. Avenatti is still licensed to practice law. So, there you go. A DCV Titan says, Renfamous is likely larger than we think. She just collapsed into itself like a neutron star. The density does match up with the posting. Android 13, thank you for the donation. SM Scorks 89 says, Nick, invite Micah Curtis, formerly of Blistered Thumbs on Channel Awesome, to your Mars Girl stream. He'll add some perspective about CA and Jew Wario. I'd love to talk to Micah Curtis before the stream, if I could do that. Android 13, thank you again. Kyo Himura, thank you for the donation. Silith says, buy a bag of jelly beans with this. I don't even like jelly beans. Let's see. Future Gadget Lab member 001 says, what's the likelihood Monica is into vor? Very high. Very high. If liking jelly beans got her all hot and bothered in her nether regions and she had to report it, then or Vic eating jelly beans, she must be into vor. Go. DFW Knight says, Mars Girl, number 15,091 on Patreon, auditioned to be Nostalgia Chick, but lost to Lindsay Ellis, who went on to be a PBS host and is number 43 on Patreon. Mars's brush with fame may have left her extra thirsty. Jason Box says, Nick, I need help. Sent you an email a while ago. Home issues over 2 owners. One owner is pissed that the locks got changed. She wants me to live there. Okay. I'll see if I can find it, buddy. Yangio says, Nick, if you're using Streamlabs and you have a smartphone, you have a discount Stream Deck. It's in Streamlabs settings. I can send instructions. No, I'm going to buy a Stream Deck because that is beautiful that it's discount Stream Deck. I got it. But I'm going to set up one with big freaking buttons right in front of me that I can press. Thank you for the offer, but I'm going to do it that way because I think the buttons are going to be better than me trying to manage a phone. I can barely manage a mouse. Black Russian Bot says, yes, way ahead of deadbeats, hashtag Hail War campaign. Boag says, fix this, Ethan, fix it now. Blue Orion Tiger says, an SJW cheated me out of $80 of website work and will threaten harassment if I try to contact her for payment. Just needed to vent. Well, that sucks. Sorry, buddy. 1K1 Nights, thanks for the donations. Finfrog says, this stream brought to you by Oatmeal Cream Sammys. They're so good. So good. And they're like 400 calories. Very nutritious. They have oatmeal in them. How could they be bad? Asia Fraser says, that moment when your supervisor walks in on Nick saying, you reap what you sow, you big fat whale. At least it wasn't during the malice B word. Nick for the fans. Oh, I apologize. Chem His Life says, this stream is definitely a moonshine stream. Phoenix Lord Asserman says, every video Zach did at the time talked about how he was moving to Texas. And I'm fairly certain he talked about it on Twitter as well. Hey, can you expect Mark Waid to be familiar with your Boi Zack at all? No. Remember, his defense is, I'm literally retarded. And that's only offensive to actually mentally handicapped people because Mark Waid is dumber than any person on earth, no matter what particular disabilities might be impairing their mental function. That's his argument. It's God, it's awful. Jacob Ceresia says, speaking of Texas, white or brown gravy? Oh my goodness, why you do this to me, fam? White gravy every time. I'm trying to think of a brown gravy moment. I guess you do a brown gravy on a non-breaded piece of beef, like a pot roast. Then you can do a brown gravy. But a cream gravy? Magnificent. Magnificent. Rolana 1 says, can a judge direct Mark Waid to quit dragging the case out and wasting the opposing party's money? Kind of. I don't know if they're gonna. Scott Knudsen says, Is burning money really a good idea? Isn't Waid on the hook for Myers' legal fees if he loses? Potentially. Dan Vic says, love when you do the thing when you read and nod. No. Lol. Thanks, buddy. Rhino says, Waid Zaid have time to burn money equals Marvel payroll. Anime Moon says, Wade's counsel is Sofa, King, We, Todd, Ed, confirmed. There you go. That's some sort of education comment with the Ed. I'm guessing that's an abbreviation. Listen, now I know the white gravy, brown gravy thing is going on in the chat right now. Let me just tell you, if you have breading, or if you have chicken, or if you have potatoes, that cream gravy will treat you right. Now the brown gravy, when you, let me help you out. You cook yourself some beef ribs, okay? Cook yourself some beef ribs. Not the bone on, the boneless beef ribs. You dump some whiskey in there to deglaze the pan. You make a nice brown gravy out of that. Mmm, magnificent. But your beef ribs don't have breading on them. You put breading on them, I'm telling you, go with the cream gravy. Go with the cream gravy. All right. Rolana 1. Oh, wait, I read that one. Where are we? Jonathan 2342 says, oh, by the way, let me plug this a little bit. On the Patreon, I'm going to do a monthly Patreon and New Project 2. If you're in my Discord, either through Patreon or New Project 2, I'm going to do a monthly private video to those to the Discord group, which will be probably a live show, cooking with Rackets. It's going to be just fun. Lady Rackets, hopefully I can convince her to help me. But we're going to cook the things that I cook. I do most of the cooking for our family. I love cooking, always have. And so if you want some Rackets recipes or whatever, consider joining the Patreon and Discord. I'll make a public announcement when that goes live, when I do the first one. But that will be exclusive Patreon content, because I need to find a way to do that. I need to give them more exclusive content. So if you're interested in that, have fun. Jonathan 2342 says, didn't Waid ask if AP was going to Austin? I don't remember at this point. Butthole Weeb says, gin tastes like mealy anal sauce and I hate it. No, get better gin. Get better gin. Man of One Title says, if Nick was in a fighting game, he would enter the ring and yell, Malice, B-word. If he got a flawless victory, he would mutter, how embarrassing, after it's over. That's true. That's true. Mr. DJ Fly Eye says, comicbook.com reports that Sony is eyeing an expansion into anime to China. Could the Vic case affect this expansion? How bad can it affect the expansion? I don't know. Those are some good questions. I'll have to look into it, buddy. I just don't know. Plum Logan says, is burning money a good strategy when you have less than money? No. Or less money in general? No. That guy says, your poor wife has to deal with your alcoholic diarrhea. That poor woman. First of all, I'm not an alcoholic. I enjoy liquor. I enjoy it on these streams. I do many of them without it. And if I don't stream, I typically don't drink. But two, I can hold my liquor better than that alcoholic diarrhea nonsense. Come on. Whenever I have the alcohol poop coming, I just will it away. I force my body to reprocess that into something sterner. Something sterner than Mark Waid's spine. Anime Moon says, how bad is it that a college dropout understands this stuff better than they do? I only had business law in high school and I could dismantle this. Attaboy. Russell, very sad. Very bad. Russell Case, but again, Ryan Pierce is working with what he's got. What he's got is a garbage client with a bad case. Russell Case says, something funny about Myers' recent campaign. It made almost as much money as Renfamous's campaign in under 2 days. Lol, keep up the awesome streams, Nick. Thanks, buddy. Will do. DFW Knight says, Twa versus Apple Tree holds 1. Texas had no jurisdiction over a Texans contract with an Ohio business to be executed in Ohio. And 2, Texas did have jurisdiction over people in Kentucky who defrauded a man in Texas by phone. Yeah, I thought so. Twa versus Apple Tree is a really bad case for them. Dr. Nerdly says, semester in practice intern wrote it. Oh, that's unfortunate. Lily Henry, thank you for the donation. Beige Devil says, hey, Nick, is it possible that Wade's lawyers are writing the response on the hopes of winning on an appeal? No, they're writing a response because they have to, and I think they know they're going to lose. But you got to still write the best response you can. Like, to give them all the credit, this is probably the best response they can come up with, and they know they're going to lose it. Kagi Onsai says, Mark Waid, the poster boy for shock therapy. Camino says, would it be Monica Soye or Ron Real? Ron Real, come on. We know. We know. Ghost of Nick's Beard says, pretty sure Streamlabs charged me while my phone died. Got charged. Pretty sure my chat didn't go through. Jew lawyers using Jew apps. Let's see. Let's see. Let me take a check, but let me check, buddy. I don't know if these are yours, but I'll read them real quick. Shanghai Ku says, let's give credit where it's due. This lawsuit is the only entertaining thing Waid has produced in his entire career. And Cowboy says, Nick, your quotes create the best memes. New favorite, eat the jelly bean B word. How dare you suggest I would use profanity? If yours didn't go through Ghost of Nick's Beard, I didn't get it, but go ahead and tag me. Well, I know you've commented before. Go ahead and tag me and I'll try and catch it. Lily Henry, thanks for supporting. Vic, by the way, you're handsome. Ooh, thank you. Thank you very much. And it's my pleasure to support Vic. Vindy says, almost got defrauded. Dog breeder lied about having certificates and gave fake breeder registration number. Nick, you inspire me to report him to cops for justice. Report him to the dog police. Report him to the dog police. Wait a minute. Eagle Loan says, not sure. No one brought this up. Waid has sent snail mail to Dunn? No. No. That can't be true. That can't be true. Okay, Mark C says, any chance of Renfamous joining the party? Stay tuned. Stay tuned for that. Renfamous, I mean, as she can only dip toes into pools without displacement moving all of the water out, and even that's a stretch. Even that is a stretch. Can you imagine the retained water in those gargantuan feet? Oh. Oh. That was close. Sorry. Renfamous is dipping her toes into several issues in very, very overt ways. She's going after Tug. Ill-advised. She's going after Anime Matsuri. You know, I need to do an Anime Matsuri stream and talk about the issues of Anime Matsuri. I'm going to work on that. Because I'm going, I believe that's the plan. I'm going to Anime Matsuri. I actually have a plan to do a fundraiser for some to get some kids who couldn't afford a convention to Anime Matsuri. Stay tuned. I'd like to do that very soon because we're coming up on it in a couple months here. I think it'd be great to get some kids who like anime but maybe can't afford it to attend Matsuri, and I hope you'll consider helping me in doing that. But I'd like to talk about Anime Matsuri. Now Renfamous, Lauren Atencio Cooper. Lauren Atencio Cooper is was quoted in an article that has since been revised, I think, to remove Lauren Atencio Cooper or L. Cooper's name from it. But she is heavily associated with Boycott Matsuri. Boycott Matsuri. Oh, you piles of trash are consistently engaged in tortious interference with the contract. And it'd be really unfortunate if we knew the identity of one of the organizers of Boycott Matsuri. One of the organizers of people who routinely spam people that they have no business, no privilege, no anything talking to about violating their contracts in Texas. It would be really unfortunate if that happened. Now, I don't know if Anime Matsuri would be interested in taking action against a giant mammal that belongs in a pool in SeaWorld. I don't know if they'd be interested in taking action against that disgusting, vile thing. However, it would be really interesting if Anime Matsuri were to try and find a law firm in Texas who might be interested in taking that case. So, I don't know. We'll see if Daddy wants to pay for a lawsuit. Maybe. I don't know. I have no information on this. I don't know if Anime Matsuri would be interested in pursuing that action. But what I do know is I have a news article, and I have the archive link to it, specifically linking an L. Cooper, which is dangerously close to Lauren Cooper, who happens to follow Boycott Matsuri, who happens to consistently talk about how she's opposed to Anime Matsuri. It would be really, really interesting if I could tangibly prove that she was an organizer because she's quoted in a publication being an organizer. And that would make her an agent of Boycott Matsuri. Therefore, potentially on the hook for, God, a lot of stuff. And that's a prima facie case of tortious interference. Wouldn't that be interesting? Hope you got $40,000 stashed away in your little duplex. Remember, I'm the one who can't afford a shipping container. Never mind that your duplex wouldn't fill half of my second house. Hope you got $40,000 stashed away in that duplex. Hope Anime Matsuri doesn't want to contend with you because you're irrelevant. That would be embarrassing. But we'll see. We'll see. Again, I have and I have to be very clear, no one has indicated to me that this is the case. I'm just telling you what I've got. And what I've got is a specific news article linking an orca to anime or Boycott Anime Matsuri. And I know that Boycott Anime Matsuri routinely attempts to interfere with contracts. And that's civil conspiracy. Because Boycott Anime Matsuri is a distinctive entity. And Lauren Renfamous Atencio Cooper is a distinctive entity from Anime Matsuri, which means we now have two parties in civil conspiracy that can be held joint and severally liable. Which means that you might be on the hook for any damages that you caused. Or that might be caused. Might be defamation per se. We'll have to see. I don't know. And either way, you're going to have to pay for that legal defense if they go after you. You're also going after Tug. Again, ill-advised. You're also going after Vic. Again, ill-advised. Because you know who has more money than you? Anime Matsuri, Vic's GoFundMe, and Tug. Okay. Sakaki Onsai says Super Steelers era was 1970s, Cowboys was 80s, but late 70s, early 80s, when the Steelers and the Oilers were rivals is what I'm talking about. 78 to 81, 82, Earl Campbell years. Earl Campbell's my boy. Blink Your Eye 1400 says, how dumb would it be for the other side to try and stir something up at a convention with Vic while the beard is present like at Kamehacon? Very dumb. Very dumb. Brian Urso. Hey, Nick. Huge fan, mate. Hey, thanks, buddy. Please check out our progressive rock band, Gideon's Mob. Our debut album is out now on iTunes, Amazon, CD Baby, Spotify, and Bandcamp. Thanks and God bless. Brian, if you're still there, please, because I'm going to forget this and I lose the super chats are harder to go back to. Please email me a link and I will buy the album and check it out myself. Progressive rock. I would love a modern progressive rock band. So send that to me, buddy. Lord Siegel says, where's Zaid? He likes to just sit in the corner and watch. Isn't there a term for people like that? I think there may be. I don't know. Courtney says, can you explain why Waid was allowed to be present or on the phone during AP's deposition? The parties can be present. Meyer was also present. He was bullied into that decision by Waid. His presence seems like further intimidation to me. I think you mean by Zaid. But either way, no. The parties and their counsel have a right to be present at deposition. Mr. Scott J87 says they had a book on Earl Campbell when I was in elementary school. I probably read that book 100 times. I met Earl Campbell. I was probably 6-7 years old. He was playing golf with my grandpa in a golf tournament. And I got to ride around in the cart with Earl Campbell and my grandpa. And he sent me a bunch of nice stuff, like an autographed hat, autographed pictures. The nicest guy. Genuinely one of the nicest people. He's fantastic. Fantastic. Okay. Butthole Weeb says, Nick, I wish you still liked anime and weren't a pleb. I'm dying for you to watch Aim for the Top, Gunbuster, and Diebuster Dad. Hashtag MD Geist blows dill hole. You blow dill hole and you know it. And you think it's mealy. Coyote Briggs says, DM'd it to you. Same name as here. You and Tug rock. Thanks, buddy. I'll check it out. Ash Wren says, please do Broly Power Maximum's Jelly Bean Dubstep. Okay, we'll do that at the end of the show. We'll close out the show with that. Ichicinco Negroni says, Nick, have you ever had a Negroni? No. Ash Wren says, please do. Yep. Thank you. I'll do the Jelly Bean Dubstep at the end of the show. Tassia says, yeah, but Alf has better one-liners than Mars Hurl. Talbot Link says, you're not done yet. I'm not. Butthole Weeb says, wow, Nick, no drunk Weeb stream. We're gonna do a Weeb stream. I need to figure out the time, buddy. And I gotta get Peach on board. You want Peach on board? I know you do. Most hate me now. You mean must. 4 months later, and Sam, Peach, and your Rekieta Law anime expert are trash. Breaks my heart. Wink. Blink your eyes. 1400 biscuits and gravy every day. That guy says it was a joke, bro. I don't even remember the joke, but I'm with you. Plum Logan says Micah Curtis is who introduced me to Zach in 2019. Luke Elmer says chat cherry bordelaise sauce is greater than brown gravy. Ooh. Jason Box says look for @live.com email. I had a relationship with the mother. She passed away from cancer. Her wishes were for me to always have a home there. I love her. Travis Whalen says whales are majestic. Renfamous cannot be compared to such majestic creatures. Renfamous is more like the Great Pacific Garbage Patch. Oh God. Yeah, that's true. That's true though. And then Bob Newbie, Lord of Noobs, says Lyle Alzado would F them up. Lord Chippy Dip says Alex Jones's deposition audio is out and it's heinous. Please do a review for your fans. Praise Jesus and God bless you, Nick. I want to do the Alex deposition. I just got to find the proper way to do it and the time. Minecraft stream when? That's morbid, buddy. That's morbid, buddy. Do it live from Greenland. Okay, let's do this. Let's do this. Where's my... Oh my God. I don't have any of this ready to go. All right. Death Bean parody. Let me get this set up. All right. You guys ready for this? Y'all ready for this? Sorry. Every cheerleading song ever. Here we go. Here is the you guys can check this out for yourself. A Death Bean parody. Vic eats a bean. All right. Oh, I gotta hold up. Hold up. Let me get all the settings right. Sorry about this. Sure. Oh, whoops. Here we go. All right, guys. Let's enjoy this real quick.
Just watch me, Riel. Give fans hugs with my right hand and sign autographs with my left.
No.
I'll take a jelly bean and eat it. After dinner, Vic just goes home and answers fan emails without turning on the television. It's because he actually gives a damn about people.
No.
Will come out in 8 years in a Sony investigation, and the witness to my alibi will be any sentient human being.
Wait a minute, that wasn't it. Let's watch. Okay, this is the Eat a Jelly Bean. I don't think that was the right one. Let's watch that Eat a Jelly Bean dubstep. Watch that Eat a Jelly Bean dubstep. That was good. Here we go.
Just watch me, Riel.
Wait a minute.
That said, because this is America, Jack. This is America. America. Eat it. Eat a jelly bean, bitch. Eat it. Bitch. Jelly bean. This is America.
Give fans hugs with my right hand.
Eat it, jelly bean. Eat a jelly bean, bitch. That said.
Sign autographs with my left.
Eat it. Eat a jelly bean, bitch. That said.
I'll take a
Jelly bean. Eat it.
And eat it.
After dinner,
This is
just
America.
goes home and answers fan emails.
Because this is America, Jack.
Eat it. It's because he actually gives a damn about people.
Eat a jelly bean, bitch.
Eat it. The sexual harassment I have no
Eat a
knowledge
jelly
of
bean,
will come out
bitch.
in 8 years in a Sony investigation.
Eat it.
And the witness to my alibi will be any sentient human being.
Eat a jelly bean, bitch. Okay. All right. All right. That was good. That was good. I'm with it. Oh my goodness, guys. Thank you all for watching tonight. Thank you all for watching tonight. You know, I love these I love the people who are doing clip shows. I love the, you know, cuz I don't have time to go through and clip out my rants. I am working. Oh, wait. There's 2 more justice chats that I'll get in just a second. I am thinking about starting a second channel called Rackets Rants and clipping them out, putting them up. But the people who do go ahead and do the clip shows and stuff like that, thank you. In all honesty, thank you. You guys, the way I see it, you bring more eyes to my channel ultimately by finding the funny stuff that I say and putting it out there. I don't have the time to do it. And again, you always have my blessing. I always appreciate if you can just go ahead and let me know that you did it. That's great. But yeah, thank you for doing that. Thank you for making these fun, like, fan things and parody things about the situation, bringing the attention and the mirth. Bringing the attention and the mirth to this situation is important. So thank you all who participate in that. I really do appreciate it. Last couple chats. Vertistrum says, you always say that your email is in the description. I never seem to find it. Am I blind or are you just a boomer? Uh-oh. F. It's not there at all. It's not there at all. Sorry. It's Rekieta Law at rekieta.org. I'll make sure and get it added to the description of the next video. I swore it was in there. I swore it was. But Rekieta Law at rekieta.org is my work email. If you Google Rekieta Law, that's the email you'll find there. It's also on my Facebook Rekieta Law page. So I apologize. I just assumed that I wasn't stupid and put it in there. Ghost of Nick's Beard says, yeah, you person of unmarried birth. I tried to get one all of you Fs to help set up a KamehaCon Kids. No one gave me any feedback to pull it off. You dick-biting person of unmarried birth. I want in. F my other comment. Super duper gay. There you go. There you go. Yeah, I'll like I said, I'm working on the Anime Matsuri thing, trying to find an appropriate charity to do that. Trying to find an appropriate charity to bring them up. So to get the kids involved, right? And hopefully Anime Matsuri will be involved in that. We'll see. I'll let you guys know. I'm just letting you know my thinking on it, what I'd like to do, especially because I'm going to be there. If I'm going to be there, I want to bring more people there, obviously. Rising Ground 3 says, I predicted 2019 will break a world record of most tortious interference lawsuits done, because these Twitter lunatics get even crazier and damaging as time goes on. But old Weeb says, Nick, watch them DVDs and do our long-awaited stream. Blink Your Eyes 1400 says, one of my friends loves your rants. Well, thank you. It's my pleasure. All right, guys, I gotta go eat something tomorrow. Keep an eye out. We're either gonna finish this case or have Miss Christina on. I don't know which one yet, unless something else crazy happens. But I really do want to finish these documents. They're very, very important to go through. Even though we know that their argument is garbage, let's see what other information is in there that might be important going forward. So thank you all for the show. I'll see you tomorrow. Same time, same place, whatever. Peace.